morning, sir. Morning. Looking handsome, sir.
अच्छा तापर जे मैट टा बोल खाइबो के
हेलो
ताको देखो
हेलो
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 साहू बाबूंकर टीम आपण
सर अब आ रही है आ गए आप निगम से बात हुआ मुकेश नीचे गया बात कर लो फोन करके बात कर लो बोल दिया करो सर ठीक है सर
भाई
सर मु गेट पाखे एंट्रांस रे सेल्फ लगे दिस बुझे ठीक है सर से हिसाब लोक पर्सनालिटी नहीं है ना हां एपटे
बड़े बड़े अपने मेडिएटर है
रणजीत चौधरी I am from Guwahati. Yeah, why not?
प्लीज आपके लिए है
ये सौरभ ना আমার जो স্ট্যান্ডিটা সেটা মানে কার তলକୁ তলକୁ তো আছে
सेट कर दो
হ্যাঁ
कोठी
ପାଞ୍ଚ ପାଞ୍ଚଟା କ'ଣ କହିଲ
ଅଛି ଜଜି ସେଟ ନେଇ ଯିବା
ହଁ ସେଟା ସେଟା ସୌରଭ ପାଖରେ ଅଛି ସୌରଭକୁ ଦେଇ ତିନିଟା ହଁ ପାଞ୍ଚ ପାଞ୍ଚଟା ସେ ଯେଉଁ ହେଇଥିଲା ସେଟା ସୌରଭ ଅଛି
ଦେଖନ୍ତୁ
তাকে করবো আমার মানুষ কেটা করবো দেখেছে মেইন প্রবলেম
वो इसके अंदर आप बैठ इसका नहीं होगा ये दीजिए आईडी ये तुम दीजिए देख
यूट्यूब चैनल
हाँ लिंक ना बिल्कुल ସେ ତମ କାର୍ଡ଼ କରିଦେଲ
କାମ କରୁଛି ଦେଉନାହାନ୍ତି ଶୀଘ୍ର ଯିବି କପୁଛନ୍ତି
ଆଉ ନେଇଯିବ
ତାଙ୍କୁ ଟିକେ ଲିଙ୍କଟା ପଠେଇ ଦେଲ
ଆଉ କାହିଁ ପକଉଛ ଆଉ କାହିଁ ପକଉଛ ହବନି ଜାଗା
କଥା ହେଇଯାଇଛି ରୂପ କାଇ ଲିଙ୍କଟା ପଠେଇ ଦେଉଛନ୍ତି
ତମେ କାର୍ଡ଼ ପକେଇଛ ନା ପକେଇନ ଆରମ୍ଭ କଲଣି ନା ହେଇନି କାର୍ଡ଼ କରିସାରିଲେଣି
ହଁ କାର୍ଡ଼ ପଡ଼ିଛି
ହଁ ତାହେଲେ ଠିକ୍ ଅଛି ମୁଁ କାର୍ଡ଼ ଆଣିଥିଲି ତ ପକେଇନି ଆଉ କାହିଁ ଆଉ କାର୍ଡ଼ ପକେଇବ ମୋତେ କାର୍ଡ଼ ମୁଁ ଦେଇଦେବି ରୂପକୁ ଆସିବେ
ଆସିବେ
ହଁ ଆସିବେନି କହିନାହାନ୍ତି ତୁମକୁ
ନାଇଁ ସେ ଆସିବେନି ତାଙ୍କର
ହଁ ସେ ଆସନ୍ତୁ
ଯେଉଁ କେତେ ସମୟ ଚାଲିବ ପ୍ରୋଗ୍ରାମ୍
କ'ଣ କହିଲେ
ପ୍ରୋଗ୍ରାମ୍ କେତେ ସମୟ ଚାଲିବ
ହେ 5ଟା ମଧ୍ୟ
ଏଇଟା ହେବନି ବୋଧେ ଏଇ କାର୍ଡ଼ରେ
ଆଚ୍ଛା ମୋର କାର୍ଡ଼ ଅଛି
243 ମିନିଟ୍ ଅଛି
243 ତୁମ ଗୋଟେ କାମ କର ତୁମର କାର୍ଡ଼ଟା ରଖ ହେଲା
ରେକର୍ଡ଼ିଂ ମରା ହେଇନି
ମୁଁ ଆକୁ ଦେଇଦେଉଛି ଆମ ପିଲା
ହଁ ଦେଇଦିଅନ୍ତୁ ଏଇଟା ଯେତେବେଳେ ଫୁଲ୍ ହେଇଯିବ ସେଇଟା ପକେଇଦେବେ
ନାଇଁ ମୋର ଲାଇଭ୍ ଅଛି ମୋ ପାଖରେ ଗୋଟେ କାର୍ଡ଼ ଅଛି ମୋ ପାଖରେ କାର୍ଡ଼
No, it is my duty.
ଆସିବେ ଗେଷ୍ଟ ଏଇଟା ଖୋଲିବୁ ତୁ ଏଇଟା ଖୋଲିକି ରିସିଭ୍ କରିବୁ ଏ କ୍ୟାମେରା ରହିଲା ବୁଝିପାରୁଛନ୍ତି ସେଇଠୁ ମୁଁ କହିଲି ସେଇଠୁ ଠିଆ ହେଇନାହାନ୍ତି ମ୍ୟାଡ଼ାମ୍ ପଚାରୁଛି କାହିଁକି ଘର
सेट कर दो टेबल से हेलो 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 हेलो
हेलो हेलो ठीक है धरी केमती कह आमको सीना लगे कहबी बट स्पीकर मैंने मुझे स्पेसिफिकली कहली से तुम जीएम कहले कि आम साउंड मगेबू बाहर कौन यहाँ कहले डाकिले जीएम हेलो हेलो हेलो
हेलो हेलो
এটা ঠিক আছে এটা ঠিক আছে জিএম ডাক हेलो 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 पार्टी जाଉଛି देखो जीएम फोन हेलो 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 भाई पछू जाए देखिए चेक करिया पड़े नहीं नहीं चेक करिया पड़े कले हेलो हेलो एमती थोड़ी दिन हेला हेलो 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 शुणु भाई हेलो 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 वीडियोग्राफी साहू बाबू को टीम रू किए थे टिके दया कर आसवे कि साहू बाबू वीडियोग्राफी रो बैटेरीटा तुम देखो हेलो 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 ठीक है परफेक्ट पाखरे आउट चेयर पकी बसियो We welcome my Lord Honorable Justice Sangam Kumar Sahu, Honorable Judge, Orissa High Court to this conference. Indeed, I would request the dignitaries and the delegates to have a huge round of applause and welcome my Lord Honorable Justice Sangam Kumar Sahu, Honorable Judge, Orissa High Court to this conference. Sir, your presence indeed encourages us. We welcome you, sir. My Lord Justice Sangam Kumar Sahu, Honorable Judge, Orissa High Court. We also delight to have my Lord Honorable Justice Kalyan Rai Surana, Sir, Honorable Judge, Guwahati High Court to this function. May I request my Lord Justice Surana to join Justice Sahu. And we welcome you, sir, to this function. I would request the dignitaries to please have a huge round of applause and welcome Justice Sahu and Justice Surana. We also welcome Honorable Advocate General of Orissa, Sri Ashok Parija sir, to this conference. May I request the delegates to have a huge round of applause and welcome Honorable Advocate General of Orissa, Sri Ashok Parija sir. We welcome my Lord Honorable Dr. Justice Bidyut Ranjan Sarangi sir to this conference. May I request the dignitaries to have huge round of applause and welcome my Lord Justice Sarangi to this conference. My Lord Honorable Dr. Justice Bidyut Ranjan Sarangi, Honorable Judge, Odisha High Court. We welcome my Lord Honorable Justice Achintya Malla Bujor Borua sir, Judge, Honorable Judge Guwahati High Court to this conference. I would request the delegates to welcome my Lord Justice Borua to this conference.
Hello, 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 hello. Hello, 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 hello. hello, hello, hello.
Hello, hello, hello. Ladies and gentlemen, please welcome Honorable Chief Justice of Orissa High Court, my Lord Honorable Dr. Justice S. Muralidhar to this conference. We welcome you, sir. May I request the delegates to have a huge round of applause for my Lord Justice Muralidhar. We welcome you, sir, to this conference. May I request the delegates to occupy their seats. We will start with the inaugural function. I would humbly request the delegates to be seated in the respective seats, and we will start the inaugural function. Ladies and gentlemen, let's have a huge round of applause and welcome my Lord Honorable Justice Subhasis Talapatra Sir, Honorable Judge Odisha High Court to this conference. My Lord Honorable Justice S. Talapatra Sir to this conference. I would humbly request the delegates to please be seated. Our honorable guests have already arrived and we will start the inaugural function. May I request my learned friends, seniors and the delegates from various states. We welcome you and we would humbly request you to be seated in the respective seats. And may I take this opportunity humbly requesting all my friends, seniors and delegates, if we can keep our mobile phones in vibration mode or silent mode so that we can smoothly have the sessions. I am sure that all of you will cooperate. I understand we have important calls, but it can be managed for the better goal. So I would humbly once again request all our guests, dignitaries and the delegates in particular to keep their mobile phones in silent mode or in vibration mode. And I would also extend my sincere thanks for the cooperation. And further, I would also request the delegate, those who have not been seated, they would be, will be really appreciating if they would be seated. Now let's welcome the chief guest of this function, none other than my Lord, Honorable Mrs. Justice B.V. Nagaratna Madam to this function. I also welcome Honorable Justice Sanjay Kumar Mishra Sir, Honorable Judge, Odisha High Court to this conference. Let's have a huge round of applause and welcome Madam Honorable Justice Mrs. B.V. Nagaratna to this conference, along with her, my Lord Honorable Justice Sanjay Kumar Mishra to this conference. I welcome you all. Thank you. Hello. We have Honorable Law Minister of Government of India, Honorable Sri Kiren Rijiju sir, as the inaugurator of this first Central Government Council's Conference of Eastern States of India. I welcome you, sir, to this conference. We have Honorable Solicitor General of India, Shri Tushar Mehta ji, with him. I welcome Shri Tushar Mehta ji to this conference. We also welcome learned Additional Solicitor General, Government of India, Sri K. Natarajan sir, to this conference. Hello.
Excuse me, Jai Jagannath. We'll start our function because all the luminaries are with us. So all are requested to take their seat and have a privilege to start our function. Already we have 10 minutes delayed, so all the delegates are requested to take their seats. We'll start the function immediately. Please. Those who have not registered, the not issue the past session. After inaugural session, we can register ourselves. But please take their seat. We'll start the function.
Good morning, ladies and gentlemen. May I request the our honorable guest and the delegates, those I understand we are really excited to see the galaxy of luminaries. May I request the learned seniors, my learned friends and other central government councils across the eastern states of the country, those who have graced this occasion by registering as a participant and delegates, to have their seats. We have specific time for the photo sessions. We will make definitely wonderful memories with our beloved guests. We will definitely cherish the memory by photographs. So may I humbly with folded hand request the delegates to be seated so that we can have the conference. We we are deeply honored and we respect the emotion. Good morning, ladies and gentlemen. It is indeed a great privilege to assemble here for an unique and wonderful and fast of its kind function, that is first conference of Central Government Councils of Eastern States of India, that is West Bengal, Odisha, Jharkhand, Chhattisgarh, Assam, Sikkim, Tripura, Nagaland, Mizoram, Manipur, Meghalaya and Arunachal Pradesh. I must say that we believe in Vasudhaiva Kutumbakam. We all are one family, but for the effective deliberation, we have confined it to the eastern states of India with a specific view and idea to have deliberation and to develop the capacity building and effective functioning of judicial system and our contribution as central government councils. We indeed welcome and we are privileged to have galaxy of legal luminaries who have accepted our humble request and invitation and been gracious enough to present here for this function. Let us welcome with huge round of applause the inaugurator of this function, none other than Honorable Union Minister of Law and Justice, Government of India, Honorable Sri Kiren Rijiju sir. To this function, I would request Honorable Law Minister sir to the dais. May I request the volunteers to escort our Honorable inaugurator of this function to the dais. And I would request again, humbly request the delegates to be seated. Please have a huge round of applause for our Honorable inaugurator, Sri Kiren Rijiju ji, Honorable Law Minister, Union Government of India. We are indeed privileged to have our chief guest of this conference, my Lord, Honorable Mrs. Justice B.V. Nagaratna Madam, who have graced this occasion as the chief guest. I welcome you, Madam, to this function. We request and we are privileged to have Honorable Chief Justice of Odisha, my Lord, Honorable Dr. Justice S. Muralidhar sir, as our guest of honor. I welcome you, sir, to this function. May I request Honorable Solicitor General of India as guest of honor, Sri Tushar Mehta ji, and I would request all of you please have a huge round of applause for Sri Tushar Mehta ji as our guest of honor. We are privileged to have two of our leaders of our bar who have been leading us, who have been guiding us, none other than the Honorable Advocate General of Odisha, Sri Ashok Parija sir, and Honorable Deputy Solicitor General of India of Odisha High Court, Sri Prasanna Kumar Pari sir, to the dais. May I request learned Deputy Solicitor General, Kolkata High Court, Sri Dheeraj Trivedi sir, to the dais. Atithi Devo Bhava. With a great amount of honor and respect, I once again, from the core of our heart, welcome all the dignitaries on the dais, of the dais. We are privileged to have the judges of Honorable Odisha High Court, judges of other participating high courts, additional Solicitor General. I welcome the Assistant Solicitor General, Deputy Solicitor General of various participating states, senior advocates, and delegates who have been who have registered and participating here as delegates. May I request the audience and everyone present here to please stand up for the national anthem.
पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल जमुना गंगा जल तब शुभ नामे जागे तब शुभ आशीष मागे गाए तब जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you, ladies and gentlemen. As I said, Atithi Deva Bhava, we always start any function by lighting the lamp, paying our deepest respect to the Almighty through our dignitaries. So may I request the dignitaries on the dais, please join for lighting of the lamp. And I would request Sri Partha Sarathi Naik, Senior Panel Counsel, Government of India, to chant Jagannatha Stotram.
कदाचित् काळिन्दी तटविपिन संगीत करबो मृदाभिनारी बदल कमला स्वाद मधुप रमा शंभुर्ब्रह्मा सुरपति गणेशा चितपदो जगन्नाथ स्वामी नयन पथगामी भवतु मे जगन्नाथ स्वामी नयन पथगामी भवतु मे जगन्नाथ स्वामी नयन पथगामी भवतु मे.
Thank you, everybody. Now may I request the volunteers to please present a token of love and respect to our dignitaries on the dais and present the flower bouquet. The conference is themed or named as Nyaya Yagya. Yagya is a term derived from Sanskrit origin, Sanskrit dhatu, judge, which means dedication and devotion. Yagya otherwise means sacrifice and also submissiveness. Nyaya is justice. The entire endeavor is to understand, as a central government councils, as the wisdom is always being understood, as a government council wins a case when justice happens to the petitioner. It is being always observed. To have more deliberation, to have discussion how to develop the capacity and how to build the capacity by performing, maintaining the ethical values, and to have interaction with the various central government councils of various states. It is being organized with able guidance of the Assistant Solicitor General, Additional Solicitor General, Deputy Solicitor Generals of various states. So I welcome once again all the delegates, dignitaries, guests to this conference, those who have taken the strain and pain to assemble here for making this event a grand success. To have a formal welcome, may I request Sri Prasanna Kumar Parhi sir, learned Deputy Solicitor General of India, Orissa High Court, to present the welcome address.
Bande Utkal Janani. In this auspicious occasion, I welcome all of my dignitaries, especially our Honorable Minister, Minister Law and Justice, Sri Kiran Rijiju, Honorable Judge, Supreme Court of India, B.B. Nagaratan ji, our Honorable Chief Justice, S. Muralidhar ji, our leader, our Solicitor General of India, Tushar Mehta ji, my elder brother Ashok Parija, Lord Advocate General Orissa. It's our auspicious occasion, and I am privileged to welcome all of our dignitaries on the decks. In front of us, our High Court judges from our High Court, Justice Talpatra sir, Justice Bidunatha Sarangi, Justice S.K. Shahu, Justice Sanjay Misra, Justice M.A. Shahu, and other High Court judges in front of us who are sitting, and then they are going to participate in this function. All the Assistant Additional Solicitor General of India, all the Deputy Solicitor General of India in different parts of the country as well as the Eastern Zone. I also welcome all the delegates, senior parent councils, central councils, and those are senior standing council in different organizations. Those are devoting their works for the country. And I also welcome press and media. Those are extend their cooperation and they are present here. Especially, I thanks to my lordships as well as our Honorable Minister. Even though different occasions we have faced some problem, ultimately we have succeeded, and we are going to organize this conference in Orissa. Lord Jagannath bless us to do so. So we have I am welcoming all of us in this occasion. So I request all of my delegates, have a patience to complete all the sessions, and it is phase by phase we will go to sessions after the inaugural sessions. And I request all of my, if there is any problem or any sorts of ignorance we have, please excuse, because we are very difficult manner we are arranging along with our teams. And especially today, I thanks to the Honorable Minister and the Honorable Supreme Court Judge as well as Tushar Mehta ji, who has inspired us to do this function. I also express my gratitude to Nataran sir, who has inspired me in all respect to how the function will be very fruitful. And also here the different parts of Additional Solicitor Generals, Dr. Ken Singh ji, Mr. Anil Singh, all are present here. And they also participate in different functions. Mr. Anil Kumar ji also there in Jharkhand, and different AGS also there. They will participate different occasions. So I welcome all of us, those who are present here. And once again I welcome everybody, and I will not take more time. So again, once again, I pray Lord Jagannath, how this function, our conference will be success, they will extend his hand and blessing. Thank you.
Thank you, sir. Now, He is a very well-known person. He needs no introduction. But it is an honor to have none other than Honorable Solicitor General of India, who has been leading us since long and representing Government of India in many important cases. So please welcome with a huge round of applause Sri Tushar Mehta ji to address on this occasion.
A very good morning to you all. Honorable Minister Shri Kiran Rijiju ji, Honorable Justice Nagaratna ji, Honorable the Chief Justice Dr. Muralidhar, my good friend, my senior and a very able Advocate General Ashok Parija ji, my colleagues Parhi ji and Virat Trivedi ji, the Honorable Judges, my esteemed colleague K.M. Nataraj, who is with us, all my law officer colleagues and friends. Friends, this is for the first time that in the eastern part of the country, the conference consisting only of law officers representing the largest litigant of this nation, namely the central government, is being organized, and I am indeed grateful to my colleague Mr. Parhi ji to associate me with this momentous occasion. When I say the central government is the largest litigant in all courts of India, I must emphasize the very heavy burden and responsibility which all of us carry, especially in the present times to come. Since last few years, the country is jumping leaps and bounds in every sphere of life, be it industry, be it infrastructure, be it investment, be it social reforms, be it legislative reforms, and directly or indirectly, all of us are a part of this very revolutionary process. Some of the facts which all of us know and needs no highlighting, but if presented in proper perspective would make us aware, the law officers of the country aware, the heavy responsibility which we carry on our shoulders. We are in the age of globalization, having the largest mobile user network in the world. We have 700 million mobile users, and we are adding one new mobile user every second. That's the pace with which the country is progressing. Gone are the days where the country was dependent upon other countries for its basic needs. Now, India stands the recognition of one of the few countries which had its own local indigenous vaccine. And I have a figure to share with all of you. The number of vaccine doses which we as a nation administered are 20 times more than the total population of United States and European Union put together. That's the pace with which the government is working, that's the pace with which the country is progressing. Leaps and bounds. India is the economic powerhouse of the world. We used to hear the word brain drain. People used to go from here to other countries. Now, people are coming back. Technocrats, former bureaucrats, other entrepreneurs, they are now coming here, and as a result, in the World Index of Ease of Doing Business, in last 4 years, we have a rapid jump of 79 positions. It is that effort which we are supposed to defend in the court of law, without being burdened by the fact that we have to win every time. As it is already said, the government always wins when the government loses and the citizen wins. That must be borne in mind by all of us, but there are certain problems where we cannot compromise as law officers, and we will have to give our best with our best of industry, intelligence, hard work and integrity. There are certain sectors like financial sector, like infrastructure sector, where we as lawyers representing the government would find that there are mostly intentional but at times unintentional attempts by some section of the society to thwart the financial progress, the economic progress, or the infrastructural progress of the nation. Whenever there is a prayer for any stay against the infrastructural project, ultimate decider will be the court, but we should not lack in our industry, integrity, intelligence and hard work to ensure that no infrastructure work is delayed because of our inability to assist the Honorable Court. Similarly, money laundering is a very, very serious issue when we talk about the economic development of the nation. In all cases of money laundering, while it is important that the freedom of the citizen, the personal liberty of the citizen is important, we as lawyers representing the government cannot forget that we are a part of a very fast growing economic growth engine, and we should do our best to ensure that nobody tries to stop it. Friends, our command is in safest of the hands so far as executive is concerned. It's in the safest of the hands so far as judiciary is concerned. It is in the safest hands, and the minimum thing which we as lawyers of the government required to do is to ensure that the perception of the executive is rightly presented before the judiciary, leaving it to the judiciary to take a final call as the Constitution makes them the final arbiter. But there is a statistics which is being prepared as to how many public projects are stalled because of various injunctions which are operating throughout the country, right from the trial court to the Honorable Supreme Court of India. I would not say that all stay orders would be without justification, but there may be large number of stay orders which may be due to our effort to bring the true facts before the Honorable Court, our efforts to ensure that the matters are heard at the earliest, our efforts to show the true facts before the court, and project that any delay in such infrastructural project should not be treated in a standalone basis, but will have to be treated as a part of an ongoing process of a nation who has already started on the economic journey, and we are very fast becoming the 4th largest economy in the world. Friends, it is indeed a privilege to sit with such dignitaries. I really thank my colleagues for giving me this opportunity. We have to hear the learned words, the words of wisdom from others. I'll not come in the way. While thanking all of you to be very patient listeners and tolerating me for a slightly longer time, I conclude my words. Thank you so much and good day to all of you. Jai Jagannath.
Thank you, sir. Your guidance with clarity of perspective, with facts and figure, indeed is thought-provoking. We appreciate and we acknowledge your enlightening words on the role of judiciary, executive and legislature for the public purpose. Indeed, your presence and your guidance is obliged. Thank you, sir. Ladies and gentlemen, now I'm going to invite such a person. We always recognize him as a path-finding and a trend-setting personality. In Orissa, he is a person who always inspires the younger generation and the entire legal fraternity. He is none other than Honorable Advocate General of Orissa, Honorable Sri Ashok Parija, sir. So please welcome with a huge round of applause, Sri Ashok Parija, sir.
Good morning, everybody. Honorable Sri Kiren Rijiju, Honorable Union Minister, Law and Justice, Honorable Justice B. Raganathnam, Judge Supreme Court of India, Chief Guest of this morning, Honorable Dr. Justice S. Muralidhar, Chief Justice of our High Court, my good friend Sri Tushar Mehta, Learned Solicitor General of India, Sri K. M. Nataraj, Learned Additional Solicitor General of India, Sri Prasanna Kumar Padhi, Learned Deputy Solicitor General of India, Learned Deputy Solicitor General of India from Calcutta High Court, galaxy of honorable judges sitting off the dais, Justice B.R. Sadangi, Justice Kalyan Rai, Justice Achintya Malla, Justice Sanjay Mishra, Justice Talapatra, Justice Sangam Sahu, Justice M.S. Sahu, and my apologies if I have missed out on some people. Law officers of the Government of India from various states, including the Additional Solicitor General from Bombay, my colleagues at the bar, ladies and gentlemen, I welcome one and all to this congregation of judges and law officers. This event is timely and important in more than one way. Not only has it created a platform for law officers of eastern states to discuss important regional and national issues in legal practice, but with the erudite presence of all the participants, this event has also brought together one of the most important pillars for administration of law and justice, the Honorable Law Minister, the Honorable Judges, and the learned law officers. India has one of the highest number of cases in various courts within our judicial system. The judicial workload of our judges is much higher compared to most other jurisdictions. As a result, judges inevitably rely on law officers to assist them both in law and with dispensation of justice. Courts and law officers play complementary roles in facilitating the rule of law. We as law officers thus not only bear a professional responsibility to conduct our briefs professionally, but also have a greater moral responsibility to further justice and constitutionalism. When we talk about administration of justice, we must discuss the rapid changes in our legal practice has undergone in the last 3 years. We progressed from being a mere frontrunner in number of cases in our judicial system to also the frontrunner in innovative technological solutions to dispensation of justice. After COVID-19, Supreme Court and various high courts have worked tirelessly to increase legal accessibility of courts by enabling and facilitating virtual platforms and electronic initiatives. The topic of today's discussion, one of the topics of today's discussion is virtual legal practice and its impact is therefore fitting to mark this moment in history. And who better to exemplify this transformation than Chief Justice Muralidhar himself? As the saying goes, cometh the hour, cometh the man. Justice Muralidhar was sworn in as the Chief Justice of Orissa High Court on 4th of January 2021. Since then, he has transformed the judicial infrastructure of the state both quantitatively and qualitatively. Justice Muralidhar had personally turned paperless much before the lawyers and judges. While carrying this practice to the Orissa High Court, he has successfully scaled technology as a tool for his continuing efforts in access to justice. Through the Virtual High Court project, the district in Odisha have now equipped with video conferencing and e-facilities which are available to be used by all. This is providing necessary infrastructure and a professional atmosphere for the advocates to file and appear in the High Court and other courts from anywhere in the state. The Record Room Digitization Center initiative with e-reading devices installed in courtrooms has kick-started the digital transformation in the state and in the country. The 14 district court digitization centers that have been set up to digitize court records have already uploaded lakhs of court records from 30 districts of Orissa for public access. In fact, 34 courts in various districts across the state are already paperless. Another noteworthy decision of the Orissa High Court is to provide touchscreen laptops to every judicial officer of the state with a view to enable the officers to work paperlessly and further digital transformation on both sides of the bench. These are only some of the many commendable initiatives the Orissa High Court, led by Justice Muralidhar, has captured in the annual report of the Orissa High Court. At the Odisha High Court, Justice Muralidhar has surpassed his own exemplary achievements by forcefully initiating the process of liberating justice from its shackles and inaccessibility. Justice Muralidhar's leadership is worthy of emulation not only in other high courts of India but also other jurisdictions. The central government and the Orissa government and other state governments have also supported digital transformation in a significant way by being responsive to the needs of the judiciary and the lawyers. Through the central government support, tribunals like NCLT and others have led the way in VC transformation during the pandemic. It was heartening to see counsels from far-flung places of the country having access to tribunals that were situated in the heart of the metropolis. Today's platform gives us a unique opportunity to share similar achievements, innovative ideas and other goals for our future so that we as members of this conference may benefit from this mutual learning and dialogue. I look forward to the 2 productive sessions ahead. Thank you.
Thank you, sir. Now, ladies and gentlemen, I am going to invite such a person who is known for his dynamism, revolutionary, visionary, and an epitome of service and serving the judiciary. He has given a new dimension and new direction to the Odisha judiciary. He is the head of Odisha judiciary, none other than Honorable Chief Justice of Odisha High Court, my Lord Honorable Dr. Justice S. Muralidhar, sir. May I request my Lord Justice Muralidhar, sir, to please address the gathering.
Namaskar. A very warm good morning to everyone. The Honorable Law Minister, Shri Rijiju, Justice Nagaratna, Shri Mehta, Shri Parija, Shri Trivedi, Shri Padi, my colleagues of the Odisha High Court, our esteemed brothers of the Guwahati High Court, the law officers present here, all the young lawyers of the panel of the central government of the Odisha High Court, all the lawyers present here, ladies and gentlemen. I am very thankful that I've been invited to speak on this occasion. I know the train is about half an hour late, so good engine drivers will make up for the lost time. So I'm going to facilitate making up for the lost time. So the good news is that I won't be speaking for long. The further good news is that when we decided to introduce e-filing in the High Court, we got excellent cooperation both from the state government and the central government. So we made it mandatory for the state government and central government to file their cases only by e-filing. It's almost a year now, and it's going on very well. I'm sure the officers of Mr. Padi have changed the way they work, and that's how it is going to be in the future. When all of us as lawyers, as judges, learn to come on to the paperless mode, some of my own colleagues who are a bit skeptical have told me, no, we have to get on to this paperless mode, and they're making that effort. And it's overall a very positive response that we've received. from the bar and also from the district bar. This introduction of courts, the virtual courts with virtual benches, has received tremendous response from the districts in Odisha, and I'm sure this will be a good path-breaking and direction showing move which can probably be replicated elsewhere in the country. I understand that this is a Nyaya Yajna, not a Jnana Yajna. So this is not the time for us to give suggestions, but perhaps listen to what Justice Nagaratna and Shri Rijiju have to tell us. I would only urge that this one session, the second working session on use of virtual courts, I would request all the lawyers here to tell us how better we can improve the system of the virtual courts so that it becomes easier for all of you to use the virtual courts and for the lawyers to use the virtual courts. If all the central government offices become paperless, it will really be a transformational exercise. Very often adjournments are sought because the lawyer says, I have just been engaged, I need papers, the previous counsel has not handed over papers to me, and invariably an adjournment is taken on that ground. If it was all scanned and all that the counsel had to be told is you just go on the server and download the entire paper book from this link, it makes it much, much easier. All that is possible now. I'm sure these measures are already being thought of because we have a dynamic law minister, and this is equally transformational in the way the central government agencies, the central agencies in the Supreme Court and their offices in the high courts can work. I think we should take advantage of this huge opportunity we have for transforming the way the legal system works. And as Mr. Mehta was mentioning, we are on the cusp of that transformation. Let's seize this moment and let's march ahead to improve the legal system in India. With these words, I wish this conference all the very best. Thank you.
Thank you, my lord. My lord, your words might be less, but I would definitely mention that action speaks louder than the words. Thank you for your gracious presence. Ladies and gentlemen, it is said in Manusmriti, Yatra narihastu pujyante, ramanti tatra devata, yatra etaha napujyante, sarva tatra afala kriya. We are indeed privileged, and it's a great honor for us. We have someone who is going to be one of the inspiring and very well-known and the popular figure in the judicial system of our country. We have none other than my lord, Honorable Mrs. Justice B.V. Nagaratna, Honorable Judge, Supreme Court of India, as the chief guest of this function. May I request, please welcome her to address the gathering with a huge round of applause. My lord, Honorable Mrs. Justice Nagaratna.
Namaskar. A very good morning to everybody. Honorable Minister of Law and Justice, Sri Kiran Rijiju ji. Is it all right now? Yes. Honorable Minister for Law and Justice, Sri Kiran Rijiju ji. Honorable Dr. Justice Mulidhar. Yes. Sri Tushar Mehta, Learned Solicitor General for India, Learned Advocate General for the State of Orissa, Sri Padi, Learned Deputy Solicitor General of India, Orissa High Court, Sri Dwivedi ji, the Deputy Solicitor General, Calcutta High Court, honorable judges who have come here from various high courts, learned law officers from the eastern part of India, and I have been informed that they are there from other parts of India also, distinguished invitees, learned members of the bar, ladies and gentlemen. I must thank Mr. K.M. Natraj, learned ASG, for being the advocate for Mr. Padi in inviting me to this conference and to deliver the presidential address on the theme of national security. This conference is called Nyaya Yagna, and we know that in a yagna there must be a focus. And I think the focus of this conference would be on national security and on digital ways of which the cases are presented, that is virtual courts. It is axiomatic that counsel appointed by the relevant governments or instrumentalities of the state owe duty to the said government or instrumentalities, and therefore they must direct their abilities towards the objectives set out by the state, its departments and agencies. Law officers serve, as we all know, on the doctrine of pleasure. However, one has to be mindful of the fact that law officers owe a duty not merely to the litigant, that is, the government they represent, but also to the court and to the other parties in the proceeding, and above all to the administration of justice, based on the principles of the Constitution and the relevant laws. The duties of law officers, we all know, is based on the on the doctrine of public trust. Hence, law officers must be guided by the fact that they function as guardians of the rule of law and due process by protecting and preserving the integrity of procedures and institutions. Let me make a reference to the onerous duties of the Attorney General for India. He is the highest law officer of the country. He has to ensure that the rule of law is maintained and that cabinet decisions are taken in accordance with law and they are legally and constitutionally valid. The Attorney General has a special responsibility to be the guardian of that most elusive concept, that is rule of law. It is rule of law which protects individuals and society as a whole from arbitrary measures and safeguards personal liberties. Hence, he is called the Attorney General for India and not just the Attorney General for the political executive. In fact, I may say, since we are using the word Nyaya Yagna, that the dharma of a law officer or a government counsel has many faces. Dharma towards the constitution, dharma towards the litigant, that is the government, dharma towards the opposite party, and of course, dharma towards the court. While it is true that law officers or government counsel are engaged by and serve at the pleasure of the concerned government, in my view, they ultimately owe a duty to the Constitution of India. Now, coming to the actual problems faced by our legal system and the way of administration of justice, we all know that the backlog of cases and pendency of cases in the courts is, in a way, inhibiting the development process of the country. It is a truism and axiomatic. It is also common knowledge that government, being the biggest or the largest litigant in each rung of the judicial system, has to play its role in the judicial system as such. I am told that the statistics are that nearly 46% of the cases in every court, particularly in the constitutional courts, is where the government is the litigant. Not just the departments of the government, but the ministries, public sector undertakings, and other autonomous bodies and instrumentalities of the state. I don't know whether there is any new litigation policy which has been enunciated, but I was aware of a litigation policy that is called National Litigation Policy, or NLP, of the year 2010, and the goal was to see that the cases which take about 15 years to conclude, should be concluded in 3 years. The policy attempted to provide a framework to handle various aspects of government litigation, such as government representation, litigation practices such as seeking adjournments, filing pleadings, filing appeals, exploring alternative dispute resolution mechanisms, and so on. Most states have their own state litigation policies, but it is felt that the NLP is too broad in its parameters and there is no accountability framework for its implementation. In fact, if you remember, I think in 1993 or 1994 in the ONGC case, when it came to litigation between two departments of the state or the union government or two public sector units, they said that as far as possible to have it settled through the very entities themselves and not through to a court. But I don't know how far that process is in place so that we don't have a situation where the two departments of the government or two entities or instrumentalities of the state are at loggerheads before the law courts. I'm sure the learned Solicitor General along with the learned Attorney General will come out with such a policy such as the judgment in the ONGC case to ensure that there is a forum before which the departments of the government or the instrumentalities of the government, even the government, central government and the state government could come together and settle the disputes and then report it before the court. The NLP identifies key stakeholders in the management of the litigation, including the Ministry of Law and Justice, heads of various departments, law officers and government counsel. But as I said, alternative dispute redressal for the government litigation is one of the surest ways that ultimately there is no escalation of government litigation in the law courts. There is a pressing need for a more incisive discussion around government's litigation burden, whether it is because it is a compulsive litigant or a habitual litigant. It requires disaggregation, litigation information for each government to identify contributory causes and provide customized solutions. What are the concerns of this policy? First, what are the various levels of governance, that is center, state, government departments and agencies against which writ jurisdiction of the high courts invoke? Second, what are the kinds of cases filed against government at various levels? For example, the difference between challenges against constitutionality of legislations and executive actions. Third, what solutions can be proposed to reduce the incidence of government litigation? Fourth, how can the existing burden of government litigation be efficiently handled? In my view, the uniform answer to the last two questions may be traced to knowledge, approach and integrity of law officers and government counsel with the advice they render to the concerned departments of the state. It is also to be borne in mind that judges are selected from the ranks of lawyers and many law officers go on to become judges. Hence, I would advise that the standards of the bar could be enhanced by the law officers, and certainly we can expect highest excellence in a judiciary drawn from the ranks of an enlightened, learned and moral bar. While it may not be possible for me to underline what approach a government counsel must take in various categories of cases, I would like to only pick on what are known as the public interest litigations. When PILs are filed, the state or public authority and their counsel must extend their cooperation in litigation which is not adversarial in nature, but to secure observance of the constitutional or legal rights, benefits of privileges conferred upon the vulnerable sections of the society, and to reach social justice to them. This requires that government and its officers do not frown upon PILs which bring about genuine concerns concerning social and economic entitlements of the downtrodden. However, the process of the court cannot be abused or for oblique consideration by masked phantoms who file PILs to secure a private end. This should be identified by government counsel in the very initial stage itself. Such PILs masquerades as crusaders for justice. Often they are actuated by a desire to win notoriety or popularity. While the ulterior attempt of some applicants in this category may be no more than spoking the wheels of administration. I may also sound a note of caution that while some prayers in a public interest litigation are very idealistic and noble, they cannot be enforced or are incapable of being enforced even if it is granted. Therefore, it is the duty of the government counsel to bring out such practical difficulties before the courts, and it serves no purpose by the courts also to issue such idealistic directions or declarations which cannot be implemented and remain only on paper. Law officers of the state must have a nuanced understanding of the concept of separation of powers, which in turn determines the precise contours and directions that can be issued in a PIL. Another aspect which I wish to highlight is that the law officers must also realize that the courts and the judges maintain political neutrality, and the only consideration of the courts is to preserve the rule of law. The role of law officers and government counsel is essential for the functioning of each of the three organs of the Constitution. Law officers must assist the court fairly and honorably and advise the departments of the government, and therefore must attempt to render prompt, well-researched, objective and reasonable opinions which will further the constitutional ideals and justice in the matter. The government also should not frown upon opinions of law officers which may be contrary to their way of thinking. The government must repose faith in the law officers, who must also display their loyalty to rule of law and to the government. Therefore, there cannot be any discordant between the government's case and rule of law. Integrity of the law officers in this context is of utmost importance. In my view, the skill and expertise of a law officer is in the knowledge that he or she possesses, particularly in the field of constitutional and administrative law, and to infuse accountability in the functioning of governmental institutions. To what extent can government defend its actions and omissions in a court of law would ultimately depend on the skill and expertise of the law officer. Whenever a petition is filed challenging governmental action or inaction, the law officers have the responsibility of seeking appropriate instructions from the government to defend the same in a court of law. At the same time, they must have the ability to correctly advise the government on the correctness or otherwise of governmental action or omission. Just as any other litigant, government relies upon its law officers to effectively defend it. No government would like to face embarrassment before a court, particularly before a constitutional court. For a government to safely rely upon its law officers, it therefore becomes imperative for the law officers to perform in a statesman-like manner, which means, on the one hand, to meet the case of the petitioners within the contours of law, and on the other hand, to prevent the government from being exposed to strictures or adverse inferences by a court of law, and to be able to advise the government on the correct path it has to take. If ultimately the petitioners have no case at all and the petition is to be dismissed, then the skill and expertise of the law officers is integral to the whole process. I would once again emphasize that all the law officers who are gathered here, and through you to the other law officers, whether of the center or of the states, to have the vital knowledge in all branches of law, and particularly to the Central Government Council, to study the central laws in a depth and to ensure that the various nuances and interpretations and latest judgments of the constitutional courts are understood in their proper perspective. Of greater importance is to be able to gauge the stand of the petitioners on the one hand and the mind of the court on the other, so as to impress upon the court to consider the case from the perspective of not only the government but also the public society at large. This again is on the expertise and experience of the law officer. By conveying the prima facie view of the court to the government in its proper perspective, a law officer can avoid adverse observations being made by a court of law by seeking appropriate instructions in the matter and for ensuring a suitable result in the case. The law officers must be able to perceive not only the effect of an impending judgment of a court of law on the government, but also the society. Not all cases against the government are frivolous, but great many of them have merit. But of course, a frivolous or vexatious litigation against the government must be nipped in the bud. Here again, the role of the law officers is of vital importance. Being endowed with such positive roles and responsibilities, their ability and position must be perceived with a view to safeguard the rule of law. This, in my view, would be real Nyaya Yagna in the court of law in the truest sense. Conferences such as this would bring out exchange of best practices that are being adopted by various law officers in the region and also in other regions, so that they are replicated in various states. On this note, on the law officers, I would like to say a few words on a personal note. I am happy to be in Orissa. I last came to Orissa in 1983 along with my father. Mr. Parasharan was then the Attorney General, and it was, I think, the Silver Jubilee of the Bar Council in December 1983. Orissa is very close to me because, being a student of history, the best chapter in Indian history I liked was the rule of Ashoka, and particularly the Dhamma policy of Ashoka. The land of Ashoka has not only given Dhamma or Dharma principles from the ancient India to our country, it has got ancient temples, intricate handlooms. This is one example. I am a fan of Orissa handlooms and handicrafts, classical dance and music. And therefore, I'm very happy that the organizers of this conference invited me so that I could again reconnect to this great state. With these few words, I once again thank the organizers of this conference for inviting me, Mr. K.M. Nataraj, Mr. Padi, and each one of you for your kind attention. Thank you. Namaskar.
Thank you, my lord. We would like to inform and welcome our honorable guest in the valedictory function, our very own, my lord, Honorable Justice Sanjay Kumar Mishra sir, Honorable Chief Justice, Jharkhand High Court. My lord, we welcome you from the bottom of our heart. Her ladyship's guidance and thoughts on dharma of law officers, litigation policy, ADR system, and enhancing the standard of performance in the court, indeed we are obliged, and we will definitely work on this. This is so helpful. My lords, in Odisha we used to call it Utkal, Utkrusht Kala ke Desh, Utkal. Now it is known as Odisha. So your lordship, your ladyship have recognized the Kala, the art of Odisha. We are indeed obliged for that, and we also will ensure that we will win your ladyship's blessings, so that your ladyship will visit more and more. And this is the second time. We would love to have you maybe every month or every quarter, so that we can listen to your leadership and we can win your leadership's blessings. Thank you so much for recognizing the effort, recognizing the art and culture of Orissa. Thank you so much. Ladies and gentlemen, he is an icon. He is a inspiring personality, not in one field, in the field of social life, in the field of politics, sports, education, and now in law and justice. If dynamism wants to get inspiration, the word dynamic or the word enthusiastic gets inspired by his activities. It is every day we see him in social media doing something or the other in various sectors, dedicatedly and inspiring the youth and the lawyers of the country. He is none other than the inaugurator of this function, Honorable Law Minister of Government of India, Sri Kiren Rijiju. I would request Honorable Law Minister, the inaugurator of the function, to please present the inaugural address.
Honorable Justice B.V. Nagaratna, the Judge, Supreme Court of India, Justice S. Muralidhar, Chief Justice, High Court of Odisha, Justice Sanjay Mishra, Chief Justice, Jharkhand High Court, Learned Solicitor General Tushar Mehta, Learned Advocate General, High Court of Odisha, Ashok Kumar Parija, our Deputy Solicitor General in Odisha High Court, Prasanna Kumar Pari, the Honorable Judges of Odisha High Court, and our Honorable Judge from Guwahati High Court, our learned law officers present here, and other members of the Odisha High Court and the officials present here. First of all, I am extremely grateful to the team of law officers, particularly Pahariji, our additional SG, K.M. Natrasji, and others. The entire team had put in lots of efforts to organize this event. In fact, it is long due. We had to postpone this event, East India, our law officers conference, twice. But today, I'm glad we could make it happen here, and in the gracious presence of our Honorable Supreme Court Judge and all the learned judges and the dignitaries present here. First of all, when I see an occasion where the bar and the bench sit together, I am excited as well as encouraged. I think that is the team spirit in which a court functions. And Indian judiciary is well known for the contributions made by the judges and the lawyers. So this kind of occasion where we have the entire team coming together and also to discuss on various important critical issues, then it leads us to many solutions. Today's the topic is very interesting. We're going to discuss about national security, the professional aspects within the domain of virtual legal practice and its impact. And the theme with Nyaya Yagna, I think it is very appropriate. First of all, let me appreciate the works which are being done by the Odisha High Court. Last time when I visited the Odisha High Court, the Chief Justice Muralidhar ji had taken me around and made me understand all the important efforts, all the reforms and the important steps taken. These are commendable. I had acknowledged all the efforts in various forms, and many high courts in our countries are doing great job, of course led by the Supreme Court. First of all, I must assure you that the Government of India and our parliament is aware of the changing times and the needs it brings along. We are very much in tune with the call of the time, and we will always be there to ensure that the justice which the common man cries is not delayed, because we don't want to even cause delay in justice which will lead to denial of justice. There are various laws, there are various provisions, rules before us. How do we interpret? How do we ensure that the intent of the legislature is carried forward? Sometimes you see lots of debates and discussion on stringent laws. Now you are going to talk about security during your technical session. I hope you deliberate it intensely with clear objectivity and also to come out with certain solutions. I had been part of the parliamentary procedure for a very long time. At times, the laws which are necessary for the country, especially when there is a situation where a particular law is required, then after some time people find that the law is not as relevant as when it was brought into. There are cases of repealment of acts, there are amendments to the acts. It is a part of the process. We have to go with the time. So when we talk about laws like Armed Forces Special Powers Act, UAPA, we had TADA, POTA, how all these laws came into existence, I don't need to go and dwell into the history, but there is always a reason behind it. And when we deliberate in the parliament in details, when we bring a law, then we understand, then we go to the intention of the legislature. Similarly, we talk about the constitutional provisions, then we refer to the debates and discussions in the Constituent Assembly. Although we have moved far ahead, now 75th years since India has attained independence, but many laws and provisions are still as relevant as it was then. So these are how our bar and bench deliberate upon these provisions. It will give us a critical view of the requirement and the necessity. Sometimes when we talk about individual liberty, human rights, which cannot be compromised, especially in a democratic setup, every member of political party must swear by its commitment to stand for the individual rights, freedom, liberty, because it is inherent part of our constitution and its spirit. But at times it comes into conflict, and there the honorable courts take a call. We have to remember that our prime interest is to secure the nation. We have to make our society full of provisions which makes it fully secured. Security doesn't come just like that. Even for your own individual build-up, you have to sacrifice many things. Then you come to a shape. Even for a sports person, for a bodybuilder, you have to really sweat out. You have to really sacrifice. Then you get a shape. To win a medal, you have to sweat years and years. In a similar fashion, to guarantee individual freedom, rights, and liberty, we have to sacrifice many things. All these provisions which we have before us, talk about it. I don't want to talk in details, but let me give you an example. To make India safe, our security forces have to give their day in, day out. To fight the terrorism, the security forces have to give their lives. The state as a whole must be fully equipped to deal with the challenges. At times, when we want to make India a safe and secure place, we need stringent laws. Without that, the freedom will not exist. As long as we have a secured boundary, as long as we have a strong state, all the things which are guaranteed in the Constitution will prevail. Otherwise, there will be complete lawlessness. In the name of freedom, if everybody runs freely, where is the law and order? Where will be the semblance of some kind of discipline in the society? So we need to strike a balance. I have full faith on our law officers. I know our law officers are doing great job in making the honorable courts understand the reality and the challenges and the problems and limitations of the government. So our lawyers, our law officers are the bridge between the court and the government, between the judiciary and the executive. Indian judiciary cannot be questioned, and especially the wisdom of Indian judges cannot be questioned by anybody. But at times, I find that there are calibrated attempts are being made, generated from inside and outside the country. I have never heard even a single person in India who says that he will not be abide by Indian laws. I have never come across anybody in our country, forget about organizations, a single person, if he is a true, genuine Indian, he will never say he will not follow the court order. Despite that, the attempts are being made to tell the story that Indian judiciary is under attack. There are attempts being made and to speak in the forums inside the country and outside India to tell the world that Indian judiciary is under crisis. The message which is being sent is that Indian democracy is under crisis. That is why I said nobody, no organization, no political party can question the wisdom of the Indian judiciary. We stand by the spirit of the Indian Constitution. No campaign whatsoever with all ulterior motives can succeed in defaming India and its democratic setup. We Indians are inherently democratic. That is why we proudly claim that we are the mother of the democracy in the world. United States may say that they are the oldest democracy, but India is truly the mother of democracy. That is why you have never seen any kind of undue revolutions which had taken place in India. We had always abide by the rules and regulations. That is why we have to believe in our system. There may be differences within the judiciary. It exists from one judges to another judge. There are differences of opinions within two judges in the same bench. This is part of the democratic principles. Everybody cannot have same opinion. In the similar fashion, the opinion of the executive and the opinion of the judiciary may differ at times. But nobody can deny the rule of law. India is governed with rule of law as the core. Supreme Court, whatever makes law, so whatever pronouncement comes from the Supreme Court, it is the law of the land. Can anybody deny it? No. But differences may come when we say that the judge's appointment cannot be done by judicial order. It is a stand taken by the government because Constitution says so. But that doesn't mean that government is disregarding judiciary. So there are misinterpretations. Recent time I was amazed to see some seminars, some group of people with a particular mindset. The only discussion in that seminar was that government is attacking Indian judiciary. Can anybody tell one instance where our present government has disregarded Indian judiciary? It cannot, and it will never, because we are here with the mandate of the people under a provision which is there in the law. We are holding the responsibility which are defined under the Constitution of India. So that is why the disregarded campaigns or undesirable, kind of a mischievous efforts being made to malign the Indian judiciary and the Indian state as a whole must be resisted by not only the legal fraternity, but every citizen of our country. We must be proud of our system. We are proud of our constitution. We feel that Indian constitution is the best in the world. That is why in this very important gathering, while we discuss about many important topics, we must ensure that we work as a team. After all, we are serving the nation. Whether you are executive, legislature, judiciary, or the ordinary citizens, we are for the nation. I firmly believe that with the commitment which we see amongst all the sections of the society, the growth story, the success story of India will never fail. The Honorable Prime Minister has made it very clear that by 2047, India has to become a developed nation. This is not a matter of choice. It is a bounded duty, and that is our destiny. We will achieve it. And to achieve that, the efforts, the steps taken are well known to everyone. Our Honorable Judge Nagaratna ji and other distinguished speakers have mentioned about various things. I will not dwell into the other issues, but let me just make a quick reference to some of the efforts which we have taken in the recent time. Now the e-courts phase 3 has started. The budget has been approved. 7,000 crores have been allocated. Now this phase 3 is an effort, and within this phase 3 period, I think Indian judiciary will become paperless. The entire effort to make Indian judiciary completely digital will become a reality. That is what I have seen in the Odisha High Court, well on course to achieve that vision of our courts catering to the need of the people. So in the times to come, we will see that there are no more demands for different benches, different courts, because everybody will be virtually connected. I have recently written a letter to all the Honorable Chief Justices. I hope Murli ji has received it. We must ensure that every district will virtually function as a bench of the High Court, because the technology is there now. We have to ensure that technology becomes a solution to all the conflicts, because it is very sensitive. Wherever I go, there is a demand for a separate bench. There is a circuit bench demand. There are calls of different kind of groups coming with conflicting demands. And this all will be obliterated once we link everything through virtual means using technology. Besides that, for the lower judiciary, the greatest challenge I feel is in the lower judiciary. We have allocated 9,000 crore last year. The cabinet had approved, and I really want our district courts, subordinate courts to function as vibrant as the high courts and the Supreme Court, so that the real place where the common people go is the lower court. How many people manage to go to the high courts and the Supreme Court? So out of close to 4 crore and 90 lakhs pending cases, roughly we have around 70,000 cases in the Supreme Court. Rest of the thing, High Court is just around 10%. So that is why I say we need to look at the lower court. The lower judiciary has to be given a priority. Now I want to visit some of the district courts and the lower subordinate courts. There must be proper rooms, not only for the judges, but for the lawyers, for the litigants. There must be separate room, toilet for the ladies. These are must. I have told all the state government that when they send proposals for the infrastructure in the lower judiciary, make sure that these ladies toilets, ladies rooms, smart rooms, these are part of the proposals, so that we can really handle things at the grassroots. Now, when we talk about ease of justice, immediately what comes into my mind is the language. Because India is such a diverse country. Many a times, the litigant doesn't know what is going on between the lawyer and the judge. So we have already made so much of emphasis on promoting the regional languages, the mother tongues. Like in Odisha, Odia should be used in all the subordinate courts. In the high courts also. Here in High Court of Odisha also, I don't know how much on that front things are being done, but we have a provision to translate. Instant translation can be done now. So we must ensure that the litigant is well aware of what is going on. Otherwise, it becomes too complicated. I was making some remarks in one Adivakta function that at times the lawyers also try to use all kind of very difficult languages and all to create impression, and the judiciary will make certain pronouncement and it flies on top of the head of the litigant who is actually the concerned person, but he doesn't understand. So we have to make the entire process so simple. Now just look at our effort. We have started very simple legislation. The legislative drafting process itself is a Herculean task. I have already instructed my Department of Legislative branch to make very simple draft. Of course, there are certain technicalities, we can't compromise with that, but if we make a bill for the parliament, we must have a simple language draft which will be attached with a bill. We are going to start that very soon. Our department has also started digitizing 65,000 words of legal glossary, and it will be made available in the public domain and accessible in the right format. So once these are done, because if you go to Tamil Nadu, Karnataka, Odisha, West Bengal, there are certain words which are very common. When we talk about regional languages, the legal terminology of certain terms must be carefully adopted. And if we use same terminology for different regional languages, it will be so much convenient for everybody. So these are being efforts, being done by my department, and we are also making lots of effort to repeal all the obsolete and redundant laws. So far, 1486 redundant laws have been removed from the statute books. Why we are piling up with so many laws after laws, and then we make amendment laws which are also there in the statute books, and making the the space so congested that the officers are confused at times. So 65 acts are proposed to be repealed in this coming ongoing budget session. Right now we are on break. We are going to resume our session from 13 of this month. So another 65 acts. Out of that, there are 8 principal acts, 16 amendment acts, and 41 appropriation acts. These are going to be repealed. Nagaratna ji was talking about litigation policy. I very well endorse the concern as well as some of the advice she had given. Litigation policy, of course, we have a litigation policy, but we don't want to call it a litigation policy as such. So we are looking at things. Many steps are being taken in the finance ministry, in different ministries, so that we can do away with all similar cases and all unnecessary appeals and all, which are all unnecessarily adding up to the pending cases and taking time of the judiciary. So there are various other issues which I have in mind, but I don't want to really get into too much details, because you will be discussing about the issues and matter which are being made part of this seminar. But I want to say one more thing. Indian judiciary, people of India are not exactly aware of how Indian judiciary functions. Sometimes I feel sad when comments are made against the judges. It is unfortunate that there are abuses in the social media platforms about judges calling names and all. If government is being attacked, if government is being criticized, it is welcome. In democracy, governments must be questioned. But it is not a right thing or not a good sight when judiciary comes under any kind of accusation or attacks. I personally want, as a Minister for Law and Justice, judiciary must be aloof, judiciary must be far away from public criticism. But the problem is, if the same group which I referred to, if they force judiciary, if they want to coerce judiciary to take up certain matters which are totally administrative in nature, which are completely executive work, then you are exposing judiciary to the public scrutiny. Because if you involve in executive work, then you are exposing yourself. Judiciary is the final arbiter of any dispute. If there are questions, confusions about anything, let judiciary decide. And judiciary decision has to be respected, and this is the mandate. But some people want to play some kind of role, and they want to force judiciary to play the role of opposition parties. Indian judiciary will never accept this situation. I can tell you, Indian judiciary, I don't need to speak as a minister. Indian judiciary itself will resist this forceful attempt to make Indian judiciary play the role of opposition party. This cannot happen. The independence of judiciary doesn't mean that it is anti-government. Judiciary is independent. The independence of judiciary cannot be questioned by anybody. This is something we have to take as a cardinal principle of our approach. We are very firm. Our Honorable Prime Minister has made very categorically clear that we must present our case properly before the honorable courts, so that the honorable judges will understand things in a better way. That is why my full faith and trust is there on our law officers. I'm guided by our law officers. If there are complications, anything which come to me, I immediately refer it to our law officers. Our Attorney General, our Solicitor General, our additional Solicitor Generals in the Supreme Court, in the High Courts, they are my legal guides. I will go by their guidance. That is why this law officers conference is extremely important. And also the participation of honorable judges is something very special. That is why whenever I see the bar and bench together, it really gives me full of confidence that this is how we work as a team. I speak out my mind, but I'm very clear that I will not go an inch here and there against the provisions which are contained in the laws and which are there in the Constitution. We are there to ensure that every Indian is protected as per law, and we will be guided by the orders and decisions of Indian judiciary. Today in this important conference, I'm sure the outcome of the conference will be extremely positive, and also in future such conferences whenever held will always be fruitful. I saw many of our law officers. Of course, this is a East India law officers of Government of India's meeting, but our law officers from all other states have also joined in. That shows the team spirit. I'm very excited to see all of them. I thought many people will not come, but almost everyone is here. And once again, Honorable Justice Nagaratna, thank you for joining this law officers conference, and Honorable Chief Justice of Odisha High Court, Muralidhar ji, thank you for your proactive support along with your entire team of honorable judges, our Advocate General from the Odisha government. I have not personally known him or interacted him closely, but I very well know that he is very well respected, and our law officers are guided by dynamic our Tushar Mehta ji, the Solicitor General, and of course our Attorney General, very well respected. Everybody in the team are very capable. That is why I could confidently say so many things. Thank you very much. So I declare the function open.
Thank you, sir. Sir, as you said that it is being repetitively postponed, but it is the love, it is the affection and regards along with the energy and to learn and to interact. The eastern states law officers, the central government councils have gathered, even if it is postponed several times. It is just the love and the spirit to work for the country, for the nation, and to maintain the rule of law. Thank you, sir. Your powerful words is like Sanjeevani to the negativity in the environment of democracy and judicial system. Your stringent laws will make the country safe. This word is the takeaway for all of us. Thank you, sir. Now, I would like to request the honorable dignitaries on the dais to permit us and unveil the small souvenir which we tried to publish as a mark of memory within a very short time. I would request the editorial board, our senior panel councils, to please join and present the souvenir, and it can be unveiled. In the name of Naya Yagya, we have tried to compile few articles. We are also thankful our honorable dignitaries to share their valuable message and blessings. And thank you, sir. Within a period of 3 days, we have tried to make it. If any mistake or any difficulties there, we seek sincere apology. It is never deliberate or intentional. We will supply the copies to the dignitaries and the delegates here. Now it's time to express our deep sense of gratitude by presenting love and respect by way of a token of love and respect by way of presenting mementos. So may I request the learned Deputy Solicitor General of Odisha High Court, Sri Prasanna Kumar Pari sir, to present a memento to the inaugurator of this function, Honorable Minister of Law and Justice, Sri Kiran Rijiju ji. Sir, there is also another special presentation by which has been prepared by a young advocate, Thakur Sangram Singh. And I should mention that our DSGI is also an artist. He used to make sketch. He has inspired and directed Thakur Sangram Singh to prepare a small surprise for you. I would request our DSGI and Thakur Sangram Singh, who have prepared this sketch, to present you, sir. Many of us would not be knowing that Sri Prasanna Kumar Pari sir also used to make sketch during his college time. Thank you, sir. Now may I request Sri Prashant Pallabji, Deputy Solicitor General of India, Jharkhand High Court, to present a token of love and respect to Honorable, my Lord Honorable Mrs. Justice B.V. Nagaratna. Sri Prashant Pallabji. Madam, I would like to take your permission that the lady central government councils have also prepared something special for you. Of course, I believe they have recognized your likingness, so that they have also got something special for you. May I request? May I request Dr. Nitesh Mozik, learned DSGI, Meghalaya High Court, to please join us and felicitate our honorable guest, Honorable Chief Justice of Orissa High Court, my Lord Honorable Dr. Justice S. Muralidhar. May I request Dr. Nitesh Mozik ji, DSGI, Meghalaya High Court. May I request Shri Ramakant Mishra ji, learned DSGI, Chhattisgarh High Court, to please join on the stage and felicitate our leader, the guest of honor of this function, Honorable Solicitor General of India, Shri Tushar Mehta ji. Shri Ramakant Mishra ji. May I request Shri Samir Pal ji, may I request Dheeraj Trivedi ji, who is there with us, to present a memento to Honorable Advocate General of Odisha, Shri Ashok Parija sir. May I request Shri Tulsi Lal ji, Assistant Solicitor General, Andaman Nicobar, to join on the stage. Shri Tulsi Lal ji, to present a memento to the Deputy Solicitor General of Odisha, Shri Prasanna Kumar Pari. May I request Shri Gyanalok Mohanty, Senior Panel Counsel, Government of India, Odisha High Court, to present a memento to Shri Dheeraj Trivedi ji. Now may I request Shri Dheeraj Trivedi ji, learned Deputy Solicitor General of India, Kolkata High Court, to present the vote of thanks.
First of all, hello, Jai Jagannath, Namaskar, Suprabhat. The Honorable Sri Kiran Rijiju ji, our Honorable Minister of Law and Justice, Honorable Mrs. Justice B.V. Nagaratna, Honorable Justice S. Muralidharan, Honorable Justice Sanjay Kumar Mishra ji, Honorable Sri Tushar Mehta ji, all the Honorable Judges of the Honorable Court, our Advocate General of Odisha High Court, Deputy Solicitor General of Odisha High Court, all the Deputy Solicitor Generals present over here in the meeting, and all the learned councils of the central government and advocates, Suprabhat. Being given this opportunity to give vote of thanks, I feel humbled. I would like to first with the august gathering which is there and the learned speakers who have given us an ashada path to the knowledge which they have, I would first like to thank our Law Minister, Sri Kiran Rijiju ji, who had explained very explicitly the relationship between the bar and the bench. In fact, I believe that the debates, judicial debates which take place between the bar and the bench resolve and actually teach us what the statute in its wisdom intends to say and implement. Safety and security, as said by the Honorable Minister, is very true in the clear day-to-day sense of the term, that with liberties comes a lot of duties. Thank you very much, Mr. Sir. Thank you, sir, for inspiring us with your kind words and enlightening us about the commendable steps taken towards the electronic court system. Once, as it was said in one of the programs by the Honorable Chief Justice of India, initially when we came into the profession, mobile phones were not allowed in courts, but now we have tabs and laptops to work with. So thank you very much to the Honorable Minister and all the Honorable Judges and the advocates who are promoting the e-system. Thank you very much. Thank you very much, my Lord, Mrs. Justice B.V. Nagaratna, for telling us what is the dharma of a law officer. Your Ladyships have also enlightened us with the alternative dispute resolution system and also has sensitized us with the cautions and the sensitization towards dealing with public interest litigations. We may not be always adversarial to these litigations. Thank you very much. Thank you very much, Honorable Justice Muralidharan, the Honorable Chief Justice of Odisha High Court, for enlightening us about how Odisha High Court is progressing in its e-filing system and digitalization. We thank our Honorable Solicitor General of India, Sri Tusharji Mehta. We have to defend many cases and he is the wind beneath our wings. He is nothing short of inspiration for us. So thank you very much, sir, for enlightening us and backing us. We thank the Advocate General, Odisha High Court, for giving us the intimation and ushering us to the knowledge as to how the Odisha High Court is developing in the justice delivery system. Thank you very much, sir. Thank you very much, all the honorable judges who have graced this occasion. Thank you very much, Natarajan sir. You have been always a great inspiration to all of us. Thank you very much, Anil Singhji sir, for being here. Thank you very much, all the DSJIs for joining this particular seminar, and thank you very much, all the learned members for being here and giving us a patient hearing. Thank you very much, all the learned advocates from Odisha High Court. Thank you very much. Namaskar.
Thank you, sir. May I request the delegates to stay back, that we will start the technical session. Very important topic, national security, our priority. So that we are running a little late. We have two distinguished personality, my Lord Honorable Dr. Justice Vidyut Ranjan Sadangi sir, and my Lord Honorable Mr. Justice Kalyan Rai Surana sir, who will be deliberating, enlightening us on this very important topic. I must assure and ensure that we every day get inspired with the extremely excellent academic acumen of my Lord Justice Sadangi, my Lord Justice Surana. So this session, which is going to be very deliberative, very enlightening, I would humbly request the delegates to stay back. There was a tea break, but we will have the tea circulation in the hall itself, so that we will save the time and we will dive into the very important topic of national security. Once again, I extend my deep sense of gratitude from the bottom of my heart to all the dignitaries who graced the occasion on the inaugural session. I'm again requesting the delegates to stay back so that we will immediately start the technical session, the sole basis and the main aim of the conference, and the topic is national security, and which is our priority. As I said, that we have two distinguished, enlightened speakers with us, my Lord Honorable Dr. Justice Vidyut Ranjan Sadangi and my Lord Honorable Mr. Justice Kalyan Rai Surana, and they will be accompanied with Sri Ranjit Kumar Dev Chaudhary, learned Deputy Solicitor General of India, Guwahati High Court; Sri Ashok Kumar Chakraborty, learned Additional Solicitor General, Calcutta High Court; Sri Khomdram Samarjit Singh, learned Deputy Solicitor General, Manipur High Court. So I would once again request all the delegates to stay back, and we will immediately start the technical session. And this would be moderated by Madam Josna Rani Sahu. I would request Madam to come to the stage so that we can immediately start the technical session. We are running little late by a few minutes, so we will try to stick to the times, because our main motto is to deliberate on the important topics that has been taken up. So I would again humbly request the delegates to stay back so that we can start the technical session. We have got eminent speakers on the very important topic of national security. I would request the senior members, those who are in the central government panel, to ensure that their state's representatives and their team is there in the hall for the technical session, which would definitely going to be very fruitful. May I request the delegates to please be seated so that we can start the technical session 1. I would humbly request all the delegates to please be seated so that we will not be more late. We are late by a few minutes. So I would request the senior panel councils to ensure their teams to be there in the hall.
Good afternoon. Good afternoon, everybody, and a warm welcome to the first technical session. Good afternoon, everybody, and a warm welcome to all the luminaries present here. It's our proud privilege to conduct this conference despite all odds. I would like to request Honorable Dr. Justice Vidyut Ranjan Sarangi, Judge, Odisha High Court, to kindly come to the dais. Volunteers, kindly escort. I would like to request Honorable Justice Kalyan Rai Surana Sir, Judge, Guwahati High Court, to kindly come to the dais. Volunteers, kindly escort our guests to the dais. I would like to request Dr. D.K. Singh, Learned Additional Solicitor General of India, Patna High Court, to kindly come to the dais. I would like to request Shri Ranjit Kumar Dev Chaudhary, Sir, Learned Deputy Solicitor General of India, Guwahati High Court, to kindly come to the dais. Volunteers, kindly escort the guests to the dais. I would like to request Sri K. Samarjit Singh, Learned Deputy Solicitor General of India, Manipur High Court, to kindly come to the dais. I'd like to again request Sri Ranjit Kumar Dev Chaudhary. I'd like to request Dr. D.K. Singh, Learned Additional Solicitor General of India, Patna High Court, to kindly come to the dais. I'd like to request the delegates to kindly be seated. I request our volunteers to present a token of love to our eminent personalities on the dais.
May I request the delegates to please be seated so that we can start the session. May I request all the delegates to be please seated so that we can have the technical session. I would kindly request the delegates to settle down, please. Before starting our working session, I would like to say some words. फानुस बनके जिसकी हिफाजत हवा करे, वो समा क्या बुझे जिसे रोशन खुदा करे. We are a country of believers. We were, are, and will be. No external force or internal turmoils can ever take us from our motherland. Since Harsavardhan of 647 BC till today, we have been invaded, bleeded, but never lost the pride of our mother. We are born to die, but we survive on our own, and with all the diversities, we stand erect. We are Indians. We believe in Vasudeva Kutumbakam. Being an Odia, I emphatically need to say, Nijo Swartha Pai Jata Nuhe Hindu, Biswa Hite Tara Prati Rakta Bindu. Before starting the session, I would like to introduce our guest, an eminent personality endowed with integrity, honesty, sincerity, ability, hardworking, prompt and meticulous reading,
with a powerful mind, deep thinking, and clear expression, coupled with an understanding of human nature and an inspiration for the young generation lawyers. He is none other than Honorable Dr. Justice Bidyut Ranjan Sadangi, Judge, Odisha High Court. Now I would like to introduce before you a well-known and distinguished personality who, despite graduating in the field of commerce, has excelled in this legal field and rose to such heights by dint of his determination, hard working, and sincerity. He is none other than Honorable Mr. Justice Kalyan Rai Surana, Judge, Guwahati High Court. Now I'd like to request Sri Ranjit Kumar Dev Chaudhary ji, Learned Deputy Solicitor General of India, Guwahati High Court, to give his welcome address.
Honorable Justice Dr. Justice Bidyut Ranjan Sarangi, Honorable Judge, Odisha High Court, Honorable Justice Kalyan Rai Surana, Judge, Guwahati High Court, Honorable judges present here today, I'll take this. Am I audible? Am I audible? Honorable Dr. Justice Bidyut Ranjan Sarangi, Honorable Judge, Odisha High Court, Honorable Justice Kalyan Rai State of Odisha. As we start the first session, working session of this conference today, the topic, national security, our priority. Ladies and gentlemen, we would all agree upon one thing, that is, with the changing of times, the dynamics of the world order has changed. The distinguished speakers in the inaugural session has referred to the economic progress of the state, our competition with the other countries, our neighboring countries. And as we progress, as our development progresses, different security threats are seen. Not only economic, we see other threats as well. Here I would like to point out one particular aspect of law which we are perhaps lagging, that is the cyber security. We have noticed that neighboring countries like China and other countries have gone leaps and bounds, and cyber security is definitely a threat to our country. And perhaps this is a field where we need to improvise. Apart from that, the threat from our neighboring countries causing demographic changes, creating unrest within the country are also threats to the country. We have got different laws by which we try to secure the security of our country. It may be the UAPA, it may be the law of preventive detention, but we are still a far way to go. And I'm sure that today, after hearing our enlightened speakers, we will go home taking a few cues from the learned speakers that will help us in tackling this enormous difficulty that is facing the country today. Without wasting any further words, I welcome you all to this technical session on national security, and I hope you'll have a great session ahead. Thank you so much.
would like to request Honorable Dr. Justice Vidyut Ranjan Sarangi, Judge, Orissa High Court, to enlighten us with his keynote address on the topic National Security, Our Priority.
My esteemed brother, Mr. Justice Kalyan Rai Shrana, Judge Guwahati High Court, and Mr. Ashok Kumar Chakrabarti, Land Additional Solicitor General, Calcutta High Court, and Mr. Kodaram Samit Singh, Land Deputy Solicitor General, Manipur High Court, and more particularly the Honorable Judge of the dais, and also the representation made from eastern zone of this country, representing the central government in various courts. I welcome them from bottom of my heart that your presence here in Odisha gives us immense pleasure that we are in one family. And the today's topic now we are going to discuss that national security and our priority. This is a too broad a topic. I believe that I'm trying to give some points to you for consideration. The national security and our priority, I just leave our priority. And I'll first take into consideration what is our national security. What do you mean by national security? First, I want to divide this in two parts, namely, number one is external security and second is internal security. Then I classify the external security as to main issue that war with neighboring countries. It is a so vast a country and it is surrounded by some other neighboring countries that relationship between our country with the neighboring countries should go on smoothly, and our relations with the neighboring countries should so compatible that we can live peacefully. And we are under threat of neighboring country so far as our security is concerned. Therefore, our external security is very important to safeguard the interest of the citizen of India. Now, coming to the internal security, I classify this as communal conflict, terrorism, Naxalism, drug peddling, and fake Indian currency. I have categorized in 5 categories, and there are other things are there, but for our discussion for today is highly essential that these should be taken into consideration for deliberation, so that at least we can find out some ways and means to save our country and to live peacefully in the country. So far as the national security is concerned, I can say that it is highly essential to take such steps so that in global level the India will take its lead, and it is now leading. I can say with all vows and with all fairness that whatever India had got the reputation in the world level, that has been enhanced like anything because of the step taken by the government from the date it has assumed its office. And that too, the Prime Minister's visit to different countries and initial stage was criticized by many of the people, but ultimately we found that that visit is itself has created a global sensation, and as such now India is leading in all aspects because of the able leadership of our leaders who are leading the country now. Therefore, there should be a rightful place in global affairs that action should be taken from our end so that they will not threat to us in the boundary of India. And there should be activities in the border itself so that nobody can threat us, that nobody can jeopardize our sanctity, nobody can stand our way to have the peaceful living in the country itself. Therefore, we are the person, we have to see that the border must be protected properly by enhancing our military force, naval force and air force. As and when the occasion arises, definitely we have to come back with the other countries indicating that we are not fearful of your threat or your action, rather we are more powerful than you and we can rise to the occasion when occasion arises for the safety of our country. Now coming to the question that the internal security is concerned, we have experienced in the meantime that there is some conflict in the state of Jammu Kashmir, even in northeast states, and left-wing extremists. Then the combating terrorism. These are the four threats on our part. We have to meet these challenges which are facing day in, day out. And after the Article 370 was removed, now the situation in Jammu and Kashmir has to be taken into consideration, because we never feel that Jammu and Kashmir ever been parted with our country. It is part of our country and it will continue with us, and that too, it will remain as it is with us for all time to come. The steps taken for removing this 370, that itself is a sufficient indication that we are united together, we live together and survive together, and that belongingness must be there for all time to come. Therefore, the security which we are now talking of, very, very important. And so, but the northeast states are also concerned. There are some disputes, that dispute has resolved, and now the terrorism has to go. Then we have to take necessary steps for protecting our people, namely giving economic security, climate change and environment, then demographic pressure, then technology disruption, then cyber threats, and the internal security. These are the things which is required on our part to take care of the issue. So far the economic security is concerned, though we have got some reservation, because we people are very hard-working people. But by giving meal rice per 1 rupee per kg, now we are destroying one class of people. That is my humble opinion, that we are destroying one class of people not to work. That is not our never a motto. They are never our motto. But we want to stand behind them to survive and right to life with dignity, which protects under Article 21 of the Constitution of India. That itself invites within ourselves, but that doesn't mean that we will give rice, 1 rupee rice per kg. That will definitely affect the sincerity and honesty of a person to do the work. Thereby, the young generation, if will be provided with 1 rupee per kg rice, then they will not have rise to the occasion to do the work. Ultimately, in future, we may face some difficulties. That is my personal apprehension, and you all will take into consider this aspect and do the best for the security of the country. Then, strengthening our compatibility, the securing our land and maritime, and strengthening our military capacity, because you have got a huge borderline, and so far as the army is concerned, we are starting from Gujarat to Kashmir, Rajasthan, Kashmir, then northeast states. That we have got the land. We require a land force. The persons who have to have the security on the border itself. So far as the naval is concerned, we have got a huge coastal border starting from Gujarat, ending with West Bengal. Therefore, in all these areas, we have to give proper guidance and security so that there will no threat of to the border to the country itself. So far as the economic security is concerned, the government has plotted different schemes for the benefit of the public. But there must be proper implementation of such scheme, and that should be taken care of at your level. Because when a government makes a policy, the same are being challenged also. The same policy has to be protected, and it is the responsibility owes on you to see that the policy should be implemented properly. And when a policy is under challenge before this court, that should be placed by the government councils appearing for the state, which even though the law is that policy decision cannot be interfered with, but still it must be justified, then why such a policy is implemented and such policy is framed, and how it has been beneficial for the society, how it comes within the purview of the constitutional mandate, so that the deliberation can be made on that basis. The court cannot interfere with the policy decision of the government. But only question I am saying that now India has got 135 crores of people. Then 135 crores of people must get the benefit of all these enactment, policies and guidelines issued by the government, and you are the protectors and you are the facilitators. Therefore, I request all of you that you must come prepared to assist the court in due deliberation, and this is assistance required, what the law minister has already expressed before you in the past session itself. Therefore, I just reiterate the same thing, and I also say that for the economic security, the steps to be taken at your end properly so that people can get the benefits. Now, major threat comes with regard to the technological development or technological security. So we are in much ahead of other countries now, so far as the computation concerned, because you see many of the people of India have gone to abroad for survival. Now they are coming back because of the reason that we are encouraging them to have better life in the own country, and that too the security has to be given in all respect so far technology is concerned. And as such, the cyber crime nowadays increasing. This is a new topic and new issues that we have to also scale down everything so that the security can be provided in all respect. And so far as the space security is concerned, water security is concerned, so far as the nuclear security is concerned, everything has to be taken care of for the smooth development of the country itself. And no doubt the country is moving very fast, and it is only because of your assistance, and I believe that this assistance will continue, and as such the steps will be taken at your end to see that the security, both external and internal, should be provided each of the citizens of the country. Now, question of priority. I left upon this issue to this August House to decide which should be given on priority. Because I understand, so far as the pandemic is concerned, that comes under the health security, and we never realized what pandemic is. But the 2019 pandemic has given a lesson to us how to combat the pandemic itself, and how the health security is taken care of, and how we have to do it. Therefore, you must see what priority can be given where. The priority has to be given as per the need of the time, need of the hour. That is my view, and subject to what you say and what you may place before the August House for consideration. There, nothing can be said that these particular items should be given priority than others. Suppose you say about the security of this nation, that itself is an important issue. But if there is no issue with regard to any conflict, then in that case we have to enjoy and live peacefully, and priority should be there, but top priority should be given some other issues which is required at the time, at the need of the time. Thereby, the priority has to be considered taking into the need of the hour, which is to be done at your level. I am very happy to give you this opportunity to me to share with you my views, and I hope that you, when you leave Odisha, you must carry a very good impression about Odisha and see that Lord Jagannath must bless you all. Thank you.
Thank you, sir, for differentiating between internal and external security, how to safeguard ourselves from external force, and how to save ourselves from internal problems, how to safeguard our borderline, and how India will lead the world, and what should be our priority. Thank you, sir, for illuminating us by giving a valuable speech. I now request Honorable Mr. Justice Kalyan Rai Surana Sarji, Judge, Guwahati High Court, to kindly address the meeting.
I'm sorry to interrupt, Mr. Chakravarti from ASJ Calcutta is absent. I request my learned senior D.K. Singh, Dr. D.K. Singh, ASJ Patna High Court, he should, Sir D.N. Singh, should come and dash the decks. Sir, please. Sir, sorry. Mr. Chakravarti has met a small accident, that's why he is not able to come. Sir will replace him. You should tell him. Sorry for interruption. Now you can.
I would like to request Honorable Mr. Justice Kalyan Rai Surana sir, Judge, Guwahati High Court, to kindly address the August gathering.
Good afternoon. I thank the organizers for extending the invitation to me to be here amongst you. Shri Ranjit Kumar Dev Chaudhary, Honorable Justice Vidyut Ranjan Sarangi ji, Mr. Khodiram Samarjit Singh, Samarjit Singh, and the learned DSJ from Patna, Mr. Kian Singh, Dr. Kian Singh. Just as Justice Sarangi has rightly said that the topic is a vast topic. I would begin with a caveat. It's okay. The thought I would be sharing with you is my personal opinion. So please do not construe this to be an institutional opinion of the Guwahati High Court. I am definitely not an expert in the field. So therefore what I am sharing with you is only a food for thought. The traditional view of security focused on the application of force at the state level, and that was a fairly narrow view hinging on military security. It is now widely acknowledged that there is more to security than purely military factors. Today's definition of security acknowledges political, economic, environmental, social and human, amongst other strands that impact the concept of security in the most basic terms. The concern for security of the lowest common denominator of every society, namely the human being, has resulted in the development of the concept of human security, which focuses on individuals. Therefore, the definition of security is definitely broad and is related to the ability of the state to perform the function of protecting the well-being of its people. Justice Sarangi has already informed this House about the various methods which the government has initiated to ensure that the security percolates to all the common citizens, food security and other benefits that are being squandered by the government. However, due to social and political reasons, the modern irony is that anything that generates anxiety or threatens the quality of life gets labeled as a security problem, with a consequent loss of focus. Logistical supports to our misguided youths by allowing them for establishing base camps have become a concern for the national security. We have laws like Unlawful Activities Prevention Act, Prevention of Money Laundering Act, Conservation of Foreign Exchange and Preservation of Smuggling Act, National Security Act, etc. We have to make ourselves more acquainted with the Information Technology Act for the purpose of dealing in cyber crimes, which has international, it doesn't have an international boundary. Now, in our country, we have been able to provide to a large extent the three basic issues earlier we had was of roti, kapda and makan. Now today, then in this regard, since you are all law officers undertaking various Herculean effort to support the stand of the government, in this aspect, when you deal with these laws relating to national security, you will find that there is hardly any evidence which can be direct to link the person from a crime. It is in this aspect, if I can take you to the provisions of Section 10 of the Evidence Act, which says things said or done by conspirator in reference to common design. I just read it. I know that you all are acquainted with Section 10, but I have a special emphasis for this Section 10 because unless you understand this provision very carefully and it is ingrained in your mind, as a law officer you will not be able to link a conspirator with an actual crime. So therefore, please excuse me if I am repeating something which you already know. Where there is reasonable doubt to believe that two or more persons have conspired together to commit an offense or an actionable wrong anything said, done, or written by any one of such persons in reference to their common intention after the time when the intention was first entertained by any one of them is a relevant fact as against each of the persons believed to be so conspiring, as well as for the purpose of proving the existence of conspiracy, as for the purpose of showing that any such person was a party to it. Now this understanding of this section would be incomplete unless I read the illustrations. A reasonable ground exists for believing that A has joined in a conspiracy to wage war against the government of India. B. The facts that B procured arms in Europe for the purpose of conspiracy, C collected money in Calcutta for the like object, D persuaded persons to join conspiracy in Bombay, E published writings advocating the object in view at Agra, and F transmitted from Delhi to G at Kabul the money which C had collected at Calcutta, and the contents of letter written by H giving an account of the conspiracy. Each are relevant both to prove the existence of the conspiracy and to prove A's complicity in it. Although he may have been ignorant of all of them, and although the persons by whom they were done were strangers to him, and although they may have taken place before he joined the conspiracy or after he left it. So therefore, a conspiracy is all-encompassing. It may entangle a person, although he was not the original conspirator, having participated at one point of time, even before joining the association, a person can still be convicted for committing an offense when conspiracy can be demonstrated. Therefore, this is one aspect where as law officers, you'll have to again and again read this provision. Now, we find that in our country, certain so-called freedoms which we enjoy are now causing a concern because it has started to divide people in linguistic and religious factors. So therefore, we must also treat these concerns as a security concern for the nation. Drugs are percolating in the country via porous borders through examination. I have also seen cases being completely demolished merely because the seized witnesses have not supported the search and seizure. And many a times, even the neighbors of the drug peddlers, they are shown as seizure witnesses and the case collapses. Therefore, through this August House, I would also the judiciary had functioned even during the pandemic. As per the data of the National Judicial Data Grid, more than 4 lakh cases. Today, the Honorable Minister Law had stated 4 crore 90 lakh cases are pending before the district judiciary. The news reports indicate that the Ministry of Law and Justice allocated only 0.1% of the union budget, which as per the analysis of the business standard, half of this amount was spent on election related expenditure. We all know that state budget is inadequate for supporting state judiciary. Funds come at the last part of the March, only to lapse on the 31st of March. Therefore, this August House will also see that to instill the sense of national security, the budgetary allocations for the judiciary also stay parked in a non-lapsable fund. Thank you for your patient hearing. Thank you. Jai Hind.
Thank you, sir, for enlightening us on political and economic security, on loss of focus, on cyber crimes, and perhaps on our Evidence Act. Now I would like to request Dr. K.N. Singh, learned Additional Solicitor General of India, to Patna High Court, to kindly address the gathering.
Honorable Mr. Justice Vidyut Ranjan Sarangi, Honorable Mr. Justice Kalyan Rai Surana, Shri Ranjit Kumar Dev Chaudhary, Shri Homdram Samarjit Singh Ji, Honorable Judges present. I have just been drafted by Mr. Pari to fill in the gap for Mr. Chakravarti. Now, I was not really prepared to speak, but like anybody in our profession, we never lose an opportunity to stand up and have our say. So I shall endeavor to do that. Now, today's topic, national security, our priority, has been very well elucidated by Honorable Justice Vidyut Ranjan Sarangi and Justice Kalyan Rai Surana. I can only just say a few things. Initially in the 1950s, when we were kids, security basically meant our borders or policing and general law and order and things like that. Now, as we have progressed these last 75 years, and as we have made economic progress, particularly in the last decade or so, which has been highlighted by the Honorable Minister and the learned Solicitor General, the concept of security has undergone a big change in the last 30-20 years. Now security means so many things, as has been highlighted by Honorable Justice Sarangi and Honorable Justice Surana. I can remember that our late Prime Minister, Mr. Atal Bihari Vajpayee, had at one stage said that water security is a very important thing which one day may lead to a world war or something like that. Now today we are seeing that water is actually a very important thing, and with one of our neighbors creating problems and our northern neighbor also doing things on the border across Arunachal Pradesh. Now water has also become a security aspect. Similarly, we have noticed that from in the 60s, when there was a famine in India, which some of us had witnessed as kids. Now that time food security was the biggest security problem, which was to some extent solved with the Green Revolution, and now again it is with the jump in our population, it is again coming to the fore. And today I personally feel that even population is a security problem. The country and planning has provided a lot, but without controlling the population, even that is a security problem that is raising concerns. Why is there so much of strife in our society? The problem of internal terrorism, Naxalites, etc. The population, the shortages caused by population is definitely one of the reasons. Similarly, so far as highlighted by Honorable Justice Sarangi, external security, internal security. So far as internal security is concerned, yes, the problem of terrorism, Naxalism, even currency which he mentioned, even that is economic aspects of the security concerns. The counterfeit currency being pushed into our country by some of our neighbors. One of our neighbors, as a matter of policy at one stage, and that is why perhaps which was tried to be undone with the demonetization. through Nepal and through the porous borders, currency, fake currency was being pushed into. And in so many ways, our economy is sought to be hurt and undermined. All these aspects of are coming in now. The question was raised about fundamentalism. Now, fundamentalism, and as Justice Surana has pointed out, it is not always in black and white that they'll be caught. Even our police forces are not well trained to undertake these investigations. They also need to be trained so that the case does not collapse and they are successfully prosecuted and punished. All these aspects will have to be deliberated upon. Now, freedom. Often it is said that security concerns and laws to protect our security should not impinge on individual freedoms, on freedoms of the individual. And some quarters raise the issue that in India, as was pointed out by the Honorable Minister, it is being said that democracy is under threat, our individual freedoms are under threat, the judiciary is under threat. Now I ask myself a question, in which other country of the world is there so much of freedom to criticize our country and our establishment? Everywhere you have people freely criticizing and even beyond the acceptable limits. Just a few days back we saw this spectacle in Punjab. Now the way the police station was attacked, and after that the person responsible goes on national television and the things he was saying, I don't know, we are tolerating it. Now even if that person, yes, he does have individual rights, he does have a certain right to freedom, but where is the line to be drawn? Can he go around undermining the state, undermining everything that we stand for? On TV debates sometimes become sickening. The way people undermine our country, the way they very existence of India, they talk of breaking away vociferous tendencies. Even that is tolerated by us, and still they say there is no freedom of speech. Which other country would give them such freedom of speech? Now these are also aspects. I'm sorry, I will not take long. I think I should wind up now. For stopgap arrangement, I think I have taken too much time. And thank you all for this opportunity. Thank you.
Thank you, sir, for your commendable speech despite short notice. Now I would like to request our senior panel counsel to present a token of love to our esteemed guests. I would like to request Shri Satya Mahanti, senior panel counsel, to kindly present a token of love to Honorable Justice Dr. Vidyut Ranjan Sarangi, Judge, Odisha High Court. Now I would like to request Sri Kailash Chandra Kara sir, Senior Panel Counsel, to kindly come to the stage to felicitate Honorable Justice Kalyan Rai Surana sir, Judge, Guwahati High Court. Now I would like to request Sri Achyutananda Rautrai sir, Senior Panel Counsel, to kindly come and present token of love to Sri Ranjit Kumar Dev Chaudhary, Learned Deputy Solicitor General of India, Guwahati High Court. Now I would like to call upon stage Shri Ghasiram Verma sir, Senior Panel Counsel, to kindly come on stage and felicitate Dr. D.K. Singh, Learned Additional Solicitor General of India, Patna High Court. I'd like to request Shri Parthasarathi Naik, Learned Senior Panel Counsel, to kindly come and present token of love to Shri K. Samarjit Singh, Learned Deputy Solicitor General of India, Manipur High Court. I would like to request Shri K. Samarjit Singh, Learned Deputy Solicitor General of India, Manipur High Court, to kindly give vote of thanks.
Good afternoon, everybody. First, I would take myself privilege to stand before you to say the vote of thanks in this technical session, first technical session, the topic of which is national security and what should be our priority. And all the three honorable speakers have agreed to one point that it's a very vast and a very diverse subject where we cannot deliberate upon such a minimum of time. So, but somehow Honorable Justice Mr. Sarangi of the Odisha High Court, they deliberated upon the importance and the requirement of getting all these benefits, getting down to the real beneficiaries. So that is one aspect. And most of the speakers, three of the speakers, or honorable speakers, have come to an agreement that the freedom that we enjoy under the Constitution should not be an instrument for disturbing our peace and tranquility and ultimately disturbing our national security. And our freedom in such a manner is coming in the way as there are limitations upon such freedoms as provided under Article 19 itself of the Constitution. And Honorable Mr. Justice Sarana of the Guwahati High Court has deliberated upon the importance of Section 10 of the Indian Evidence Act. As to the importance of the words, the relevancy of the things or the words that are taken by one of the conspirators going down to other conspirators. So that is the importance. And but with the limited time given to Dr. D.N. Singh, London Solicitor General, in the shortest possible time he has deliberated upon the importance of this demonetization and its impact on the pushing around of the fake currencies into this country through various mediums, and the impact that it had in our national security scenario of the country. So that way, we were truly enlightened by your learned all our speakers, and we thank you very much from the bottom of our heart that you have deliberated upon well in these subjects. And I thank on behalf of the organizers, all the honorable judges of the high courts and honorable all the learned additional solicitor generals and all the deputy solicitors, all the senior panel councils and all the central government councils who are present here. Thank you very much.
Thank you, sir. With the permission of the chair, may we close the first technical session. We are really indebted for this thought-provoking discussion. And I would like to request the dignitaries and the delegates to have lunch, and within 30 minutes, immediately 30 minutes, I would request everyone to congregate once again for the second technical session. We are running late by almost half an hour, So I would humbly request everybody's kind cooperation to stick to the time. Then we'll have our second technical session, and
ঠিক আছে
Hello. Hello. Hello.
କିଛି ଜାଣିନି ଆଗ ଉପରେ ଚଳିବ ଯାଉଛୁ ନା ଆଜ୍ଞା ମୋ ଇଚ୍ଛା ହବା ଯାଏ ମାୟା ଛୋଦି ମୁଣ୍ଡ କିଣ
हेलो 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 साइड कर देंगे तो कैसे साइड करो? मैं खुद लगा पूछो, खुद लगा उससे साइड कर।
I request all the delegates to come and sit with their chairs, and we are going to start the second sessions. So you all are requested to honorable judges are ready, so we must ready prior to them. So please, all are requested to extend their cooperation and I request all the delegates, please come and जो हमारा डेलीगेट्स ने बाहर में है वो आ जाएं. We'll going to start the second sessions. Both the working sessions are so important, so this session also equally important. You all are requested to come and join with the sessions. Already you have direct for 10 minutes. Please. All the volunteers are requested to call all the delegates to the hall. Odisha जो माने volunteers अछंती सबो delegates मान को request करी क्या बसंतु. We'll start the second session. Then the concluded session will start from 3:30. Please. धीरज जी, हमारा जितना एसजी डीएसजी साहब है, ये अपना अपना स्टेट की जो अपना डेलीगेट है सबको बुला लीजिए. विल स्टार्ट द सेकंड सेशन प्लीज. बाहर में जो लोग खाना खा रहे हैं थोड़ा तुरंत आ जाइए. विल स्टार्ट द सेकंड सेशन. I request all of my friends in Odisha, the senior panel councils and CGs, they are their volunteers. They are requested. They should mobilize our delegates. How to come to the hall. Panda and Chandrakant, you please go to the ground floor and ask everyone to come. Bibisar bhai, आपण तो गोड़ा खराब. संजीव भाई, please समझो डाकुन ना. आराम भाई. All are requested to come, please.
May I request all our esteemed guests to please be there in the hall. We will start our next session. ରମାକାନ୍ତ ବାବୁ ଦେଖନ୍ତୁ ଟିକେ କିଏ ଅଛନ୍ତି ବାହାରେ ଗେଷ୍ଟ ଡାକି ଦିଅନ୍ତୁ କାଇଣ୍ଡଲି ଗେଟିଂ ଲେଟ୍ ବାଇ May I have your kind attention, please? I hope all invitees are in the hall. And those who are not there, I request again, please be there. We'll start our third session. May I have kind attention? I request all the invitees to have their seats. May I have your kind attention, please? May I have permission to start this session? I request, please, all dignitaries be seated on their respective seats. Namaskar, Jai Jagannath. This is our third session where we are going to have a talk on the very interesting topic that we have decided that is called professional aspect within the domain of virtual legal practice and its impact. May I take the privilege to welcome Sri Mato Kato, Learned Deputy Solicitor General of India, Guwahati High Court, Itanagar Bench, to the dais. Please welcome him. May I invite Honorable Judge Sri Barua, Judge of Calcutta High Court, Sri Anil Chandrabal Singh, Additional Solicitor General of India, Bombay High Court. May I request Sri Sudipto Majumdar, Learned DSGI, Calcutta Jalpaiguri Bench, to be on the dais. Sir, please. Sri Sudipto Majumdarji. May I request Sri Vidyut Majumdar, Learned Deputy Solicitor General of Tripura High Court. Sri Vidyut Majumdarji. May I request to be pleased on the dais. Sir, please. Please give a grand welcome to all our dignitaries. Now may I request friends to give flower bouquets to respected dignitaries. Respected esteemed guests, my seniors, my colleagues, it's the time to have a great discussion over a topic which is really is in virtual mode. And the topic is decided, as you all know, that it's a professional aspects within the domain of virtual practice, legal practice, and its impact. May I share 1 to 2 sentences on this issue? That in this new era of the virtual mode, we all are little bit having experience on this issue, and there are some positive things and negatives and pros and cons of this virtual mode of practice. But as you all know that when you are introducing any new issues, new topic, new methodology, then everywhere, anywhere you will are supposed to face some difficulties, and out of that only we have to find out the pleasure and the enjoyment out of that. And I hope this is a new system introduced in our legal practice, and both from the side of bench and bar, they all are trying to accommodate themselves in this issue, and it is in fact going very cool, and we hope that it will do best in the future. And on this topic, I would request Sri Mato Katoji to give his welcome address. Please, sir. Sri Mato Katoji.
Good afternoon. Namaskar. I, on behalf of the organizing committee, the first Central Government Council, Eastern states of the country, heartily welcome Honorable Mr. Justice A.M. Bujurbarwa, Judge of our own Guwahati High Court. And I also welcome Anil C. Singh, Learned Additional Solicitor General, Bombay High Court. And I also welcome Sudipto Majumdar, DSJ, Jalpai Bench. And I also welcome Vidyut Majumdar, DSI Tripura, and I also welcome all the Central Government Council and Senior Final Council and CCC of different high courts and the tribunal on this second working session too, on a very important topic, professional aspect within the domain of the virtual legal factories and its impact. So this is one of the important topics, as we have already experienced in the virtual, the legal practice during our during this COVID period also. So how this important is need to be delivered and hear from His Lordship on the subject expert. I once again welcome each and every one of you in today's working session too. Thank you so much. Thank you.
Thank you, sir, for this wonderful welcome to this session. Now may I request Honorable Justice Sri Mahua, Judge Guwahati High Court, to kind give an address, Lord. Please.
Very good evening, good afternoon, in fact, to all of you. Jai Jagannath, Namaskar. In fact, I have a very close connection to Orissa because I did my graduation from this place. The topic, as I understand, out of the long sentence, I could remember 3 words: professionalism, virtual method, legal profession. So I link up the 3 and take up my topic. By virtual method, a most rustic form of understanding a virtual method is that it will be screened in front of you. You will be addressing the screen, and from the screen somebody will pop out and say, give a reply to you. This is what we started with a virtual method. But over the years down the line, at least for the legal profession, we have gone much, much forward. When we speak of virtual method and the legal profession, basically I can think of 3 core aspects. 1, a lawyer giving legal assistance to their clients through the virtual method. 2, by the virtual method, the court proceedings are being carried forward. And 3, it's actually a little new concept which may not be very prevalent here in India. It's called e-lawyering. E-lawyering is basically, these lawyers normally they don't appear in real courts or in real proceedings. They put up a portal. They're available 24 hours. People can have legal assistance from the portal, and the persons operating the portal will be responding to it. I'll come to that a little later. When we think of a virtual method, my first experience with virtual method is during the peak of the first wave of the COVID, around in the year 2019. Our Chief Justice one day decided that the judges will be sitting in the chamber itself. The virtual arrangements will be put up before the in the chamber itself. The lawyers will have the option to either appear from their residence or they may also come to the courtroom itself, but the judge will be inside the chamber. I asked the Chief Justice that if I have to sit in the judge's chamber in the court and attend in a virtual method, why can't I sit in my own residence and do it in my residence chamber? It comes to the same thing. I was told that, see, COVID is there. If you go to hold a court in your chamber, people will go, the germ may be going inside your residence. Avoid all this. Do it from here. I disagreed. I said, no, I want to try out doing it from my residence. And he said, yes, you can try. What I did initially was, I have put on simultaneously 4 computers. First one was used as a screen for the video conference with the lawyers, that is the normal what we see. Second one, all the files were digitalized, whatever were presented before me. The second computer screen was used to take out the digitalized pleadings, etc. of the parties. The third computer was used to directly connect with the SCC online or the local law reports that we are having. So if anybody makes a citation in their presentation, that we can see it there itself. And the fourth computer was used to continuously put my email on, and so that if anybody under virtual method, if they want to present any document, etc., which is not only in record, you can scan it, put it in my email, and within a minute I can see it. And as it happened that as I was conducting the court proceeding from my residence, at a subsequent stage in the COVID came that all the courts were closed down. And Justice Surana must be knowing that as I was operating from home, our Chief Justice gave me the responsibility that you continue with the court all along. You cannot stop. I said, well. So only one court was functioning basically around that time. And it was a huge success. It was not only a huge success, a very serious matter, constitutional matter came up which had to be decided very urgently. Means either the order of the governor had to be stayed or a matter had to be heard. So I preferred to hear the matter. The hearing continued continuously for 40 days and the judgment of 100 praise was delivered. Why I am referring to this is not to highlight any achievement of my mind. What I am, by referring to this, what I mean to say, that by the virtual method, it is possible to really carry forward our judicial system. But saying so, I also have to agree that there is also a bit of a flip side to the entire aspect. I give you just one example. A very reputed senior lawyer from Delhi, one day he appeared in my court, in the physical court, in the actual court. He made such a forceful presentation with a good impact that it was something to have been seen by the young lawyers. A few days after, he made a request that he wants to appear through the virtual mode. The attempt to make a same forceful, impactful presentation was there. But frankly speaking, it appeared that it was basically a synopsis of what the presentation was made the earlier day when the presentation was made in the physical court. And the third attempt, the same Senior Counsel attempted to make through the virtual mode, miserably failed because that day something happened with the system that whenever he speaks there is to be a huge echo and no one can hear anything out of it. So this aspect I am referring for only one purpose. Because of the word professionalism that has been brought into the topic on which I have to speak today. I compared the two presentations, one made in the real court and the one made in the virtual court. As I said, the virtual court presentation was to some great extent a synopsis of what was made in the real court. This is where the professionalism aspect comes in. Even if you are addressing the court in a court proceeding through the virtual means, you don't think in your mind that you are doing it virtually. Think you are actually physically presenting the same thing in the court, so that the same enthusiasm, same manner of presentation is also there in the virtual presentation. And this is possible if I am saying it from my own experience, but because I had conducted the virtual court for a very, very long period of time during those COVID days. Once I got used to the method of a virtual court, after some time it did not appear to me that I am not sitting in the physical court or that I am actually looking at a screen and conducting the court and somebody is appearing in the screen. The whole situation gets so ingrained in your mind that you lose that sense of feeling that you are actually sitting in the virtual court and it appears that you are actually there in the physical court itself. So a little more prevalence of the virtual court method will definitely lead to this kind of a situation, that the feeling that comes in a virtual court, which is a little different from the regular court, that will slowly go away. Now, as I started my topic, that I basically split it into three aspects. On the first aspect, that a lawyer giving the legal advice through the virtual means. This method will be very, very helpful for many. Because normally the legal profession is quite localized everywhere, at least in India, and not only in India, I think in the everywhere else. Localized, I mean that in a given place, it is only basically the local lawyers who attend to the legal requirements of that place. So that again depends on what quality of the lawyers are present in that place, because I come from the Northeast, and in Northeast the situation may not be same as in the rest of India. In some places the quality of the lawyers may not be to the liking of the persons who seek legal assistance. So especially in respect of those places where the quality of the lawyers may not be to the expectation of the persons who seek the legal assistance, if the virtual method is not available for that litigant or that person seeking the legal assistance, either he has to go to the local lawyer of whatever capability it may be, or the choice is to go to the next bigger place where the better quality lawyers will be available. But if the legal assistance can also be provided through the virtual means, the person who may be located at a place which does not have a very high quality of local lawyers may still have the same better quality of legal assistance which he can otherwise obtain from a different place because of the prevalence of the virtual means. But again, here also there is a flip side, that in many places, as far as my knowledge, the quality of the internet may not be of that high. So I think the Honorable Law Minister in the morning statement was made that some 7,000 crores had been made available for carrying further forward the virtual system. I believe that if some of that amount can also be used to improve the internet facility in especially the far-flung areas, it will add to the cause of promoting the virtual system, so that people from the other far-flung areas can also have the legal assistance through the virtual means having connected. About the second aspect of conducting the court proceedings through the virtual means, I have already spoken a lot on my own experience and what I could have by sitting in the court through the virtual means. But one aspect of the matter is that it's not actually an aspect that what somebody had told me or discussed with me. When the virtual means is on, in any court, a lawyer from any place can appear. When this happens, there is a tendency for the litigants to engage a much higher caliber lawyer from, say, Delhi or some other places. And feeling is doing the rounds that the local lawyers of that place may be impacted to a certain extent, because if the major briefs are taken away by the higher level lawyers from the outside, the local lawyers may be to some extent affected by it. The state feeling maybe to some extent it has some substance to it also. You can't wholly say that it is not. Because if during the COVID days where I read one article regarding the Allahabad High Court. Places like Noida, etc. are also within the jurisdiction of the Allahabad High Court, And Noida is a highly commercial place where most of the commercial litigations used to come. When the physical courts days were there, these litigations used to come to the lawyers of either Lucknow or Allahabad so that they can have their profession. But when the virtual mode was put in place, the litigants from Noida normally used to go to Delhi, which is anywhere very nearby place, engage the Delhi lawyers and used to conduct the proceedings through the virtual means. So on the basis of that article I read and the feeling that some people are expressing, the aspect may not be wholly correct. But at the same time, there is another positive side to it also. The local lawyers who otherwise would have remained confined to their local places now will have their own opportunity to even appear before the Supreme Court also through the virtual means. This is again a plus point. Normally, litigations in Supreme Court are stated to be little expensive. But if this alternative means is available to the local lawyer itself to appear before the Supreme Court by virtue of the e-filing method, which he can do it from his own place, certain class of litigants may also now come up who otherwise may not have gone to the Supreme Court because of the huge expense. But because the opportunity to present a case now may be available locally, the local profession would also develop. So it's not only everything is negative, there are a lot of positives to the entire aspect. And other aspect that I would like to point out is that now most of the courts are having their live streaming. When I started my career as a young lawyer, I remember that in one matter, Mr. Soli Sarabji had appeared, and to oppose him was the then Attorney General, Mr. Parasaran. So I was very excited as a young lawyer that such legal luminaries will be presenting their matter before the Guwahati High Court. Let me have the opportunity to watch them in detail. So that's how I could, of course, gather some experience also from them as to how lawyering at a higher level used to be done. Those were days when these methods were not there, so only opportunity of by seeing the two legal luminaries only on one occasion. But now by virtue of the live streaming, many legal luminaries can be seen by many lawyers from all over the country to gather their experience. This is one of the positive aspects of the entire aspect. And then the next positive aspect that would be, as the law minister had also indicated to some extent, the virtual proceeding facilities will now also be extended to the district level and also to the other subdivision or the smaller town level. If that is so, the same principle as I already stated, that by watching the live proceedings of the court, even the lawyers from the district level or the smaller town levels can also gather some legal acumen as to how to present matters before the High Court. And through the virtual means from their own district itself, now they can present their matters. And from this point of view, they can improve their professional acumen in the legal profession. And on the third aspect that I had referred regarding e-lawyering, the other day, Mr. R.K.D. Chaudhary, he showed me one article. From there, I could gather the concept of e-lawyering. From the article, what I could gather is that e-lawyering is that there will be a category of lawyers who basically may not be going to the physical court or the physical profession, or they will just set up a portal for themselves, which will be available 24 hours, as I already stated. Anybody can get access to that portal, but with a rider that more complicated legal problems perhaps cannot be a solution found through this e-lawyering portal method. But at least the small legal issues, we all have our experience as a lawyer that whenever we go to some marriage party or something, etc., once a person comes to know you are a lawyer, he will always have one small question to ask, like how this will be this or how that will be that. Why this is happening? Because it's happening because to get the legal answer to his question, the person must either have an appointment with a lawyer, formally ask him, get the answer, or he take a chance with the lawyer who is coming across in a marriage party here and there and ask the question. For these kind of smaller legal issues, I sincerely believe that if the system of e-lawyering can also be given more prevalence and made more widespread with adequate publicity, the small legal issues of the people who they may have the smaller questions, they can easily get the answer from the portal itself. And maybe this way we'll carry forward our virtual method even further. But in spite of all the small drawbacks here and there, or the little inconveniences here and there, I sincerely believe that the virtual method is here to stay, and it is bound to increase further. And I believe that even the professional standards of the lawyers as a whole over the country, especially in the localized level, will increase even further. And I wish all the best to everyone. Thank you.
Many thanks to Honorable Judge. Now may I request Sri Anil Singh ji to kindly update us, please.
Honorable Justice A.M. Bujor Barua, Judge Guwahati High Court, other honorable judges of various high courts who are present here, the additional Solicitor Generals of India of Jharkhand and Patna High Court, all Deputy Solicitor Generals, Panel Council, Lawyers of Union of India, ladies and gentlemen. Justice Barua has expressed his view. I can simply conclude by saying that I concur with his view and close my speech. But since Mr. Pari has invited me from Bombay, I will have to utilize his 10 to 12 minutes which he has given me to speak on the very important subject, which is the need of the hour, that is the impact of virtual hearing on the legal profession. First of all, I express my gratitude and I am extremely grateful to Mr. Pari and other organizers, the convener, the co-convener, for giving me this opportunity for being present here and express my views. Friends, the preamble, Article 14, Article 39A of the Constitution provides equality before law, equal protection of law, and what is more important is that nobody should be deprived of any legal help, legal assistance for any reason whatsoever. Therefore, when we are coming out with any mechanism, any new system, including the virtual hearing, this will have to be kept in mind. Now, the question before all of us is, are we in a position to fulfill the expectation of common man from the present legal and judicial system, or to fulfill the expectation of the founding fathers of the Constitution? We all know that legal system has been facing various challenges. There has been challenge of delay in disposal of cases, cumbersome procedure, high cost of litigation, outdated laws, media trial, quality of legal aid, and most important is the lack of infrastructure. Therefore, it is our responsibility as a lawyer, and especially as a government counsel, to see that the trust, faith, and confidence of common man is maintained in the system, and especially the poor and downtrodden, whom we should provide and impart justice as it is expected by the Constitution. The Supreme Court in one of the judgment has said that judicial service as well as legal service is not like any other service. They are mission for serving the society. And therefore, when we are evolving this virtual hearing practice, we'll have to keep this in mind. As mentioned by the Honorable Solicitor General in the morning, that even if the government loses a matter, it is the citizen of the country who wins, and therefore it is just like government winning the matter. Justice Nagaratna also mentioned that we owe a duty to the Constitution. And therefore, ultimately, when we are coming out with virtual hearing, providing a virtual platform, we have to see that ultimately it is beneficial to the people of the country, especially people who are staying in the rural and remote area, people who are downtrodden and poor people. They have an easy accessible to the justice delivery system. Now, as rightly mentioned by Justice Barua, that there are some advantages, there are some disadvantages, but ultimately the future is of virtual hearing. I have slight different opinion on this, but to some extent I certainly agree that now in the future time, since the government is also proceeding ahead, the Supreme Court of India, the E-Committee, the Honorable Chief Justice of India has also time and again has been saying that we should go for virtual hearing, virtual mode, e-filing, and etc., so that it will help us in easy disposal of cases, expeditious disposal of cases. It will reduce the cost of litigation, and ultimately the justice will be accessible to everybody. Now, therefore, let us see what are the advantages we have, because now we had in pandemic, we have all seen that we have been working virtually. Large number of matters were heard and disposed of by virtual hearing practice. In fact, even the court has been working and functioning with full strength by having only 30 or 40% of staff. In fact, in Mumbai, I have an experience, we have been practicing in Mumbai, that we had 30% staff, 40% staff, but all the judges were sitting. In pandemic, all the judges have been working. Initially, they were taking only the urgent matters, and thereafter even the regular matters were taken up by virtual hearing, and large number of matters were disposed of. Now, few advantages which we have of virtual hearing is that it is more accessible than the conventional physical court. It is more affordable because what you require is only a smartphone. It is litigant and citizen friendly because you can conduct matters from any part of India and argue in any court in India, which also save the cost. One of the difficulty which we face in the metropolitan city, especially in Mumbai, that to reach the court premises, in fact, we the lawyers in Mumbai, we travel 3 hours, 4 hours per day to reach the court premises. Most of the lawyers, they are traveling 3 hours, 4 hours. There's a traffic problem, there's a parking problem, there's a security issue, there's a space problem in the court, and certainly the virtual hearing will reduce all this burden, and it will help the litigants and the lawyers also. There are certain category of cases which can be certainly heard by virtual hearing, especially appeals. Some tribunals like appellate tribunals like TDSAT, Intellectual Property Appellate Tribunal, the NCLAT, all these matters across the country can be heard virtually because you don't require the presence of the party. E-filing in the court, going paperless, is also of a very it has been very helpful because it reduces the human effort for physically maintaining the papers or preserving the papers that the voluminous record of the court. It also helps the lawyers in their office to maintain, it is very difficult nowadays to maintain all the voluminous records. So therefore certainly e-filing, virtual hearing, this has been helpful. The benefit to the female lawyers, senior citizen, handicapped, physically challenged, that is also of a great help when we go for virtual hearing. And as I mentioned, that large number of infrastructure may not be required for the purpose of virtual hearing. Recently there was a very interesting subject which came across in the Bombay High Court, and I must share with all of you. There was a matter before a single judge. The issue was whether a transit bail or an interim bail can be granted by the High Court where the applicant has an apprehension, the accused has an apprehension that he will be arrested or where he resides, but the offense has been committed in some other state, or the FIR has been registered in some other state. So whether a temporary interim arrangement or temporary interim bail can be granted, or a temporary interim anticipatory bail can be granted, that was an issue before a single judge. One of the single judge of our High Court said that no, there is no provision under 430th, and therefore there is no question of granting interim bail, and therefore he rejected the application. After a few days, a matter came before another judge. The another judge differed, and the judge said that no, according to him, there can be a interim protection granted, interim bail, pending for some limited period, so that the party can approach the jurisdictional High Court or the Sessions Court in some other state. The matter was referred to the division bench. I argued for the Union of India before the division bench. And one of the arguments which came into my mind, I advanced before the court, is that now in view of the virtual hearing, e-filing, it is not necessary a party or a lawyer to go to a jurisdictional High Court or a session court for the purpose of filing and arguing the matter. Now if you have these facilities, and in future if this facility has to be given, then where is the question of making a provision for transit bail or granting transit bail or interim bail till you approach the jurisdictional High Court? The court has taken into consideration our submission. Now even two judges, they felt that this is a matter of greater importance, and therefore it is referred to full bench. The matter is pending before the full bench. So these are how we have, the new systems have been evolving. Now virtual hearing, therefore, to all this on all these issues is very important. Now during COVID time, normally within 24 hours when person is arrested, is produced for remand before the court. So when there was a first remand, physical presence was normally made. But thereafter for judicial custody, extension of judicial custody, it was done virtually. And therefore you save time of the court, you save time of the police, the protection which is granted to the accused to bring to the court and take back to the jail. Therefore all this time is saved, and certainly to that extent the virtual hearing has helped all of us and has been helping. Now when you talk about some of the disadvantage of the virtual hearing, one thing which I personally feel, and especially for junior lawyers, that we all have learned a lot from the bar. We call the Bar Association or the bar as a mother of every lawyer and the judges, because what you learn from the bar, you can't learn from your office, sitting in your office and sitting in your chamber. Large number of advocates are enrolled in all over India. Now it is very difficult to get good seniors. Even if you get good seniors, they are so busy that it is hardly that the seniors train you. When you are sitting in a bar room, there are many senior lawyers sitting in the bar room. You have a discussion, deliberation, you can go for seeking assistance from senior lawyers, you can discuss law, you can watch the senior lawyers arguing in the court, and you can learn a lot from there. So this is the disadvantage which you have if you go for virtual hearing, because all those facilities, the court atmosphere is not available. And according to me, for a lawyer, especially the junior lawyers, this is very important in the junior days of practice, because you learn a lot from the Bar Association, you learn from your seniors. And certainly, And this is not possible when you're sitting in your chamber and arguing a matter virtually. So that is one of the disadvantages, according to me, a junior lawyers will have when it is only and only virtual hearing. There has been a lot of experience which we have seen nowadays that in virtual hearing, the code of conduct is not being followed. We have seen lawyers arguing in t-shirt, lawyer arguing for a market while shopping in a market. We have seen lawyers has been smoking on the screen, eating food, drinking tea, coffee. So the decorum of the code is not being maintained, and some lawyers have been seen as in a different condition, which I need not express here. So it has been disturbing because the code of conduct is not being followed when you go for virtual hearing. So that is also a very important aspect. In fact, I will feel that the Bar Council of India and State Bar Council, they have framed the rules, they have framed the code of conduct and etiquettes. But that doesn't relate to the virtual hearing, and therefore now the Bar Council will also think from that angle, and they will have to frame new rules or guidelines for professional ethics and etiquettes when you are arguing a matter virtually. So I personally feel that these are all issues which will have to be dealt with, because ultimately there are advantages, there are disadvantages. Few suggestions which I have, because in the morning there was a discussion that what ultimately when we are deliberating and discussing, because this is something like we call in Hindi manthan, and our Indian culture is such that we are used to all this manthan, and we always deliberate and discuss, and we are always receptive to changes in the society, and we'll certainly accept this change of virtual hearing, but how, in what manner, to what extent it has to be, and that is also has to be seen. Therefore there has to be a balancing. I personally feel that instead of going fully virtually or fully physically, you can have a category of people like old people, senior citizen, handicapped, people who are unable to attend the court. Certainly they can argue the matter virtually, but as far as possible, I feel even today, nothing is better than physical hearing if you are present in the court. Now friends, therefore, one suggestion which I would say, I would feel is that there has to be some new code for the purpose of virtual hearing by the Bar Council, and there has to be the proper frame, we have to frame a proper rule or amend the High Court rules to codify the hybrid virtual system for clarity and uniformity. We'll have to resolve the technical issues like how to tender documents, find ways for judges sitting apart, because there are sometimes division bench, two judges are not sitting together, then the mechanism will have to be worked out. Regular workshop will have to be taken for training the lawyers, judges and the staff when the matters are heard virtually. I heard a matter last week when it was being argued in the Supreme Court. The Maharashtra government matter is going on the Supreme Court before the first court. It's a constitutional bench. Justice Chandrachud is heading the bench. And when Mr. Kapil Sibal was arguing, Justice Chandrachud said that we already had a training program for the lawyers, and again we have a second session where we are training the lawyers as to how you can argue the matter in a better manner when you are arguing virtually or from the iPad or from your laptop or from the mobile phone. Lastly, I think we should also have a nodal officer in each High Court, because that nodal officer, we can approach him if there is any technical problem, any technical glitch or any difficulty. So these are how we can redress our grievances before the officer. Therefore, ultimately, friends, I feel that by and large the virtual hearing has been helpful to all of us in pandemic. It is even helpful now. Even it will help all of us in future to see that at least three challenges can be met. One is for speedy disposal of cases, lack of infrastructure, and cost litigation. The litigation of cost can be reduced. These three challenges can be met. But there has to be balancing, when to go for virtual, when to go for physical, and how to, or hybrid. So this will have to be discussed and deliberated again and again, and we'll have to find out or evolve the new mechanism in that sense. Thank you very much for inviting me.
Many thanks for these valuable suggestions and the address on the this topic, Lord. And may I request Sri Sudipta Mukherjee Majumdar ji to speak few words on this topic.
Honorable Justice Achintamalla Vijay Barua of Guwahati High Court, Mr. Anil C. Singh, Additional Solicitor General, High Court of Bombay, Mr. Martha Kato, my friend, DSGI, Guwahati High Court, Manipur Bench, and Mr. Vidyut Majumdar, DSGI, Guwahati. Dignitaries of the dais, honorable judges, and my friends. I virtually, whenever we say, I totally agree, we use the word virtually. But this word has a catch in itself. As Mr. Singh was brilliantly pointing out, it is a two-faceted coin. I was listening to Mr. Singh's address and before that his lordship's address. It has got certain obvious advantages with inherent disadvantages. And one thing that every lawyer over here, present over here, would swear by his heart is, we will miss the demeanor of the litigant, which is very important in litigation. That can only be had in a physical hearing. But this virtual hearing is a thing of the future. It has come to stay. It will stay. We have to modulate and develop ourselves so that we can cope up with a better and deliver a better service to the litigants through virtual mode. And obviously, something of a hybrid system should be there. Because I just remembered, I had an occasion to discuss this very thing with His Lordship, the Honorable Chief Justice of Sikkim High Court. And His Lordship has expressed his view that in some parts of Sikkim, and not only Sikkim, in some parts of India, we will agree that internet connectivity is totally absent. There are certain parts of our country where I am standing does have the network. If I take one step to my left or right, the network goes. So these issues are to be kept into mind before we jump into the bandwagon of virtual hearing. But it is a thing of future. It has come, it will stay, and we are to adopt. Thank you for inviting me and allowing me to share this dais and offer a few unprepared words. Thank you.
Thank you, sir, for your valuable time and suggestion on this topic. Now, may I request Ravi Patnaik ji, Senior Standing Counsel, to go for felicitation. Ravi Patnaik ji. To Honorable Justice C. Barua. Sir. Thank you, sir. Now may I request Sri Udit Jena, Senior Standing Counsel, to please to felicitate Sri Anil Chandrabal Singh. Please. Now may I request Sri D.N. Lenka sir, Senior Standing Council, to felicitate Sri Vidyut Majumdar ji. Vidyut Majumdar. Thank you, sir. Now may I request Sri Devendra Sahu sir ji, Senior Standing Council, to felicitate Sri Mato Kato ji. Sir, please. Now, may I request Sri Jitendra Naik sir, Senior Standing Council, to felicitate Sri Sudipta Majumdar ji, DSI Calcutta Jalpai President. Thank you, sir. Now may I request Sri Vidyut Majumdar ji to give his vote of thanks on this topic. Sir, please.
Good evening, everybody. Namaskar. Honorable Judge, Guwahati High Court, Mr. Justice A.M. Bujur Barua, and the learned Additional Solicitor General, Bombay High Court, Mr. Unil C. Singh, DHI Guwahati High Court, Marto Karto, and DHI Calcutta High Court, Sudipta Majumdar, and in the inaugural session, Honorable Law Minister was present, and Honorable Judges Supreme Court and other Honorable Judges were also present. I am expressing my great regards to them also. And the Honorable other judges and additional Solicitor General and Deputy Solicitor General and senior advocates and central government litigations, central government councils, other members of the registry, ladies and gentlemen present here. And the Honorable Justice S. Talabatra, Judge, High Court of Odisha. I am Mr. Majumdar, Deputy Solicitor General, High Court of Tripura. I would like to mention that our High Court was established on 23rd March 2013. Prior to that, it was under Guwahati High Court. And at present, Justice T. Amarnath Gaur is our acting Chief Justice. I would like to share that at present in total, only 1,350 cases are pending in our High Court. And out of that, approximately only 110 cases of central government litigation are pending for disposal in the High Court of Tripura. It's a privilege for me to attend this conference, and I feel proud for them. I, on behalf of all the central government councils and law officers, convey my deep regards and hearty thanks to all the esteemed dignitaries present here today in the first conference of Central Government Council of Eastern States of India. We all, the Central Government Council, will remain grateful to all of you for being with us. I am very much thankful to the Deputy Solicitor General of India, Odisha High Court, Mr. P.K. Parshi, who worked hard for organizing this conference. I would like to thank all the law officers who are associated with this conference. and who have worked hard to success this conference. I would also like to thank the transportation and accommodation team. I would also like to thank the press and media for covering these events. I would also like to thank who worked hard behind the screen. I, on behalf of Central Government Councils and law officers, express deep regards and thanks to all. Finally, I would like to conclude with the few words of Mr. Justice P.N. Bhagavati. Quote, government alone will never be able to do it. It is for the people themselves who must utilize law for the purpose of bringing justice at the doorsteps of large masses of the people of country. Thank you all.
With the permission of the chair, may we declare this technical session closed. Thank you, my lords. Thank you, honorable dignitaries. We will start with our valedictory function immediately. Our honorable guest for the valedictory session has already arrived, and as we are running late, I would request all the delegates to be please seated. We will start the valedictory function right now. I would request Learned Central Government Council Devasis Tripathi sir to coordinate the valedictory session.
Namaskar, good afternoon everybody, and we are heading towards the valedictory session. Sir. One short announcement. The refreshment tea will be served here, and there is no need of going outside, and we will continue the session here. We are heading towards the last and concluding session. Our distinguished honorable guests are with us, and I humbly request Honorable Sri Justice Sanjay Kumar Misra, the Chief Justice of Jharkhand High Court, and Honorable Sri Justice Sri Subhasis Talapatra sir, Judge Odisha High Court, to adorn the dais, and I request our volunteers to escort his lordships to the dais. I request Sri Prashant Pallav ji, Deputy Solicitor General for Jharkhand High Court, Sri Anil Kumar ji, Additional Solicitor General of Jharkhand High Court, and Madam Sangeeta Pradhan ji, Deputy Solicitor General, Sikkim High Court, to adorn the dais. A token of love and affection to our distinguished guests, Atithi Devo Bhava. As said from the beginning, this is Nyaya Jagya. These two terms, Nyaya and Jagya, in between one term comes, that is Dharma. I remember the most discussed chapter of Mahabharata, that is Jakhya Prashna, where Yudhishthira answers every questions which are put to him by Jakhya, invisible Jakhya, and one of the question was, what is Dharma? And Sri Yudhishthira replies, Veda vibhinna smrutaya cha bhinna nana muninam matayascha bhinna dharmasya tattvam nihitam guhayam mahajana jena gatah sapantha. That is the path which is directed by the realized. And to simplify this, again Jakhya asked to Yudhishthira, Yudhishthira, please reply in one word, what is dharma? Sri Yudhishthira replies, dharma is nothing but dakshata, that is skill development. And going one step ahead, we say jato dharmas tato jaya and nyaya mama dharma, and for which we are assembled here. And this is a part of our dakshata improvement, skill development of all our law officers of Government of India. And on this occasion, I may say, nyaya and dharma are two sides of the same coin. And on this occasion, I request Sir Prashant Pallabji to give the welcome address. Sir.
A very good evening to all of you. It's a matter of immense pleasure for me to welcome my own Chief Justice, Honorable Justice Sanjay Kumar Mishra ji. My Lord's journey in the field of law has remained inspiring and very, very motivating. My Lord, after graduating from University of Law, no, my Lord. So, but my Lord, this assembly is for all Eastern Zone, my Lord. So, my Lord had topped in higher judicial services in 1999, and after, in 2009, elevated as High Court judge. I can understand how fortunate Odisha Bar is to have my Lord as judge for 12 long years. We, as a member of Bar of Jharkhand High Court, in 2 weeks itself, has felt that we are blessed with a guardian who will just motivate the bar with all transparency in imparting the justice. My Lord, we are very, very grateful that you have spared your valuable time to grace this occasion. My Lord was with us yesterday celebrating Holi, and today my Lord is in Odisha sparing his valuable time. Huh? This is also my Lord. My Lord, Justice Subhasis Talapatra ji, he has been elevated as a High Court judge in Agartala and has been transferred to Odisha High Court. My Lord, as a lawyer, had acclaimed his distinguished practice in the field of civil, criminal and constitutional matter. My Lord, I welcome you from bottom of my heart, and we are really grateful that you have agreed to grace this occasion, my Lord. I also welcome my learned Additional Solicitor General, who happens to be the first Additional Solicitor General of High Court of Jharkhand. Let me share one thing, that my learned Additional Solicitor General, for a short span of time, from 2002 to 2004, was also appointed as district judge, but he chose to come back to the bar and lead the bar. He is a celebrated lawyer on the criminal side. In 2015, he has been designated as a senior counsel, and 2022, he has been appointed as Additional Solicitor General. Sir, I welcome you from my bottom of my heart. I also welcome Srimati Shangita Pradhan. Let me share one thing. She is the youngest Deputy Solicitor General of India, Sikkim High Court. And she is doing marvelous job in the field of law. And all ladies must acquire motivation from Srimati Shangita Pradhan, who is having 2 baby child, a kid of 2 years. Still she is not missing her domestic role and delivering her official duty. I welcome you, madam, on this occasion. I extend my deepest gratitude to all of you who have spared your valuable time to grace this occasion. I won't waste much time. I know Honorable Justice Mishra is from Odisha High Court and from Jharkhand High Court, so everybody would like to hear words of wisdom from him. Thanks, and thanks to all of you.
I humbly request Honorable Sri Justice Subhasis Talapatra ji to give his address. Sir.
Say good afternoon. I know it is very difficult session to keep you awake, but I believe this will be the shorter version, because my friend Sanjay Mishra is now the Chief Justice of Jharkhand High Court. His oratory would definitely enchant you and enlighten you. All the law officers from the 9 high courts of the eastern regions, the dignitaries on the dais and of the dais, I congratulate you all. This is a kind of a manthan, I should say, rather better than a jagga. Jagga is to dedicate and manthan to do that what we have done so far. There is a very important aspect in every profession, that you churn, look back and come to a new transformed state. I think the experience that you have shared from the morning will just motivate, inspire and give you the more strength to work hard. There is no alternative to work hard, those who are holding this position, because you do not know that whether the next night you can sleep or not, because the next morning maybe there is a very important matter. You have to prepare yourself throughout the night. Situation has changed. The ideas of justice are changing every day. Earlier, what was the idea of justice? Courts were not that congested. A person with a complaint used to appear before or reporting to the court, matter was taken up, matter was disposed of, is happy or unhappy going to the appeal. There was not much discussion. But now what we have today, the 47 millions of cases are pending in the different courts. People look at the court system with a little bit of, I should say this is a big question, that whether the justice would at all be available to us. If this perspective we keep for any discussion regarding judicial institution of India, now the new this paradigm that we are in now, that not only the access to the justice in old manner is very material. Now we have to ensure the justice is delivered efficiently, in time and in a non-expensive manner. The 3 attributes of the justice is very important, and all the 3 attributes are devoured by one common plague, is called the delay in the proceeding. I have no answer. I think that no persons in this auditorium has any answer to that. We need a systematic change in approaching our cases. I will highlight and flag 2 or 3 syndromes that my career, about 32 years in this institution, that I have seen. That one thing is that even in 2021, a Supreme Court decision has empirically observed that there are 46% of the litigation in our system are frivolous litigation. Just if you stop that flow of the frivolous litigations to and allow them to not allow them to cross the threshold of the main adjudicating process, this will be little bit less burdened institution. And how to do that? And what is the role of these central government law officers or the other law officers who are representing the various states? There, when you find that this litigation doesn't have any substance from the day one, you point out to the court that this is this. If in the threshold exercise you do not become very strict, I think our future is very bleak. Nowhere in the world such amount of 46% of the total litigation, when it is observed by the Supreme Court as the frivolous litigation, you just can imagine that if it grows out and out. On the other day, our Advocate General, we are having a chat, he was saying that we have now started a new jurisdiction called the representation jurisdiction. Those are appearing in the constitutional code as, I think, do understand what I am indicating too. The one writ petition is a file, the prayer is direct the state government to dispose of my representation. Just I am telling you that every day in a constitutional courts, 150 matters are being listed. Out of that, 50 matters are disposed of with a direction. The representation that has been filed, the state government should dispose within such and such period. What happens this kind of a litigation is that after the representation is disposed, that gives another cause of action. You are not looking at the core of the controversy, not the court, not the lawyer who is presenting it. Lawyer may have an interest, the fiscal interest in it, but ultimately system is completely getting this burden and coming down. Its efficiency gets decreased every filing of this kind of a litigation. Second thing, that we are not actually executing the legal regimes that our statute contemplated. We are not executing that. It is a lot of a criticism for all the state governments and the public servant. That by way of 1976 amendment in the Code of Civil Procedure, one section 80 was incorporated. You all know that why before filing against the state or any public servant, you have to serve a notice laying down what is your grievances, what the relief you are going to, if the reliefs are not granted in the suit. My question, why these notices are not seriously taken by the state governments, is instrumentalities or the public servant? I do not know what is the experience in the state of Orissa, what is the experience in the state of Jharkhand, what is the experience in the state of West Bengal. I have no doubt, but it's a question always traveled through my mind, that if these notices against the state, or for a matter of the writ of certiorari, when a representation of the demand is made to the state government, whether those are seriously taken by the state government, public servants, or its instrumentalities. Here is the role of the law officers of the central government or the other state government. They should impress upon the state government that you just introduce a mechanism where this notices, demands is be seriously considered. Like a system of ombudsman. People must know that this is the fate of my representation by the state. And my personal belief is that if this system is introduced, out of the 100 notices or the claims are staked, that at least 70% will not come to the court. My intention is to say that we must stall the inflow of insignificant, frivolous litigations to the system. If we can step, actually the quality of the judging, efficiency of the institution, and integrity of the institution can be properly maintained. And the justice is not only the attribute of the state, nor it is an attribute of the people who seeks the justice, not the judge. It is a function of this triple contribution make it is a form of a justice. So what the Honorable Law Minister has said, I completely support his proposition. In respect of containing and managing the frivolous litigation, there should be a very important dialogue, effective dialogue between the bar and bench. That what should be the strategy to stop this inflow of frivolous litigation. This frivolous litigation eats up the serious litigation. This frivolous litigation eats up the persons to come to the court and get hearing in an early time. So that is the one thing I would like to say, that we must work hard, and we also introduce the legal regime to contain this kind of the frivolous and insignificant litigations to come to this higher judicial institution. I give some statistics and you can compare with it. In the US Supreme Court, pendency is now 178, and in the Indian Supreme Court, pendency is now 87,000. Because they have structurized their legal regime the way they have built up, that you all know there is before this, in any division bench of a high court decides a matter and the party aggrieved by the order, earlier used to take a certificate that there is an important point of law so that they can file specially before the Supreme Court. Just look and review. The filing of this certificate has become abolished. Because without certificate, the apex court is entertaining things under Article 136 of the Constitution. So the right to appeal this order by UFA, noticed by the High Courts, have been gradually, we do not know how, it has been completely eradicated from the system. But there, the other jurisdiction that we are concerned with, I had been to, in a tour to the US federal courts. I tell you one thing, that the way they proceed for a suit to take, suppose I give you one example in a trial, criminal trial, you also participate sometime in a matters like this corruption cases, sometimes you appear before there also. The first session will be a meeting with the lawyers by the judge. They will design the entire trial. What will be the date for framing of the charge? What will be the date of the examination of the witnesses? What will be the date of examination of the accused? What will be the date of the judgment? They know from the day one. And professionalism has reached to that peak, they beat all the dates. And so they can deliver the judgment much early. But still we are grappling with our problems. I find in my course, the Central Government Council sometimes state that we have not received the para-wise comment, or we have prepared the reply, it has been sent for the waiting. I sometimes tell also the associates of Mr. Pari that in this regime of this digital technology, these are stale submissions from after a few months or 1 year or two, we will not allow this kind of a submission. Because in your fingertips, you can send the para-wise comment. We would expect within 3 days, this draft will be prepared, and by the next 3 days, that will be vetted. Total 7 days. And I would also request that if we implement the law properly, we can save the delays in the prosecution. I do not know, I just complete by stating, I do not know what other people will do, but I will like to do what I should do. I will devote my time, my labor, and my intellect to fasten the process so that a person waiting outside the court, who had knocked the door of the court, can get the justice early, and a quality of justice he deserves in the democracy, in the rule of law. So you have a very important role to just show yourself up as the person who is serious in the business, and that role will encourage the system to transfer to a better, efficacious and fruitful system for delivering justice. Then the Jango will be perfectly all right. Otherwise, it will be everywhere it will come, but it will lead us to nowhere. Thank you, everyone. Thank you very much.
Thank you, Lordship. You have rightly reminded us our duties, responsibilities, and also our commitment towards the society, and being the part of the administration, how we have to deal with the matters of public grievance if it comes to us, either in the way of representation or notice under Section 80 of CPC. Now, no need of introduction. Honorable Sri Justice Sanjay Kumar Misra. Honorable Justice Sanjay Kumar Misra needs no introduction. He is,
Jagannath Swami Nayana Pathagami Bhavatu Me. Good evening, Namaskar. Honorable Brother Justice Shubhasis Talpatra, Honorable Mr. Justice Achintya Mala Bujor Barua. Did I get it wrong? India for the state of Jharkhand, Madam Sangeeta Pradhan, then Deputy Solicitor General, Sikkim High Court, the Central Government Council's additional Solicitor Generals, Deputy Solicitor Generals from various states in the eastern part of India, ladies and gentlemen. This is in fact a very laudable step on the part of the Office of the Deputy Solicitor General for Odisha to organize such a important discussion or seminar. And these topics that has been chosen is very relevant also. That is national seminar, national security, and this professional aspect of virtual legal practice. I was a trial lawyer in the trial court. My first experience as a trial was as a trial judge, not as a high court judge. I didn't come to the high court like all four of you. I have come from the district judiciary. So I speak of very simple things, ground realities. In course of the 12 years I served as a judge of the Odisha High Court, I was given, in the later part of my career, I was given the responsibility of chairing two committees. One is the National Security Act Advisory Committee, and the second is the Advisory Committee for Detainees under the PIT NDPS. You know PIT NDPS Act? It appears it's not ringing a bell with anybody. It is it is called Prevention of Illicit Trafficking in Drugs and Narcotic Drugs and Psychotropic Substances Act. Just like NSA Act is there is also a NDPS PIT Act where a detention order can be passed, and there are two committees for that in the Odisha High Court. I was manning them. And I also sat with senior judges in the early stage of my career as a judge of the High Court, which were hearing habeas corpus applications against preventive detentions. One thing I marked in all the cases, and in fact all the cases that has been allowed, one thing is common. The delay in disposal of the representation of the detainee, or the delay in disposal of the or the order that is passed by the state or the Union of India. As I believe in the state government, it is the Home Secretary who passes the order of detention, final order, and it is immediately has to be communicated, and he has to be given a chance that you can make a representation, and the representation has to be put up before the concerned authority, and immediate decision has to be taken. And in the central government, it is the additional secretary, judicial perhaps, and of the Home Department who has to take the decision. And all the cases where my senior judges has written, there is a violation of, I think, clause 5 of Article 22 of the Constitution of India, and the detention is, the order of detention is quashed. Now, as the Central Government Council, it is your duty to see that this does not repeat itself frequently. You read all the judgments on this quashing of the detention order. Invariably, the ground is about 75%. This is the ground for which delay in disposal of the representation, delay in passing of the order has been the ground for quashing the matter. So, as the advocates of the central government, it is your duty to see that this aspect is also taken up by the concerned authorities. It doesn't go to the, I don't think it is it goes to the minister or the home minister or the law minister. It is disposed of, it is delegated to a particular additional secretary, a very senior IS officer. He can take a decision even at night in his official chamber. So I am not going to big questions of national security. Otherwise, just I am sharing what I have experienced and felt as a judge or as a member of the as a chairman of the advisory committee. The second topic was professional aspect of virtual legal practice. Now, virtual legal hearing of cases has become a reality. It is actually as good as a physical hearing. Virtual hearing is as good as. Just before the preceding session, the speakers were telling about the disadvantages and advantages of virtual hearing, and they advocated that a hybrid hearing should be there. I totally agree with the same. In this imperfect world, you cannot find a perfect solution to anything. Every object, every system has advantages and it has its disadvantages. Somebody was telling that a razor, जो barber's razor होता है, it has advantages and disadvantages also. If it is used properly, it can be used for shaving your beard. If it is not used properly, it can be used for cutting your throat also. So every system has advantage, disadvantage, and we have to adapt it to it. Now, pandemic has ruined lives of many Indians. What to say of Indians, human beings. It has taken away lives of near and dear ones. It has taken away livelihood of persons. It has played havoc in the human life. And we hope and pray, Lord Jagannath Ji, that no such pandemic should be repeated in the lives of human beings. But at the same time, pandemic taught us one thing. It taught us to think out of the box. आपने कभी 2019 में सोचा था कि आप में घर में बैठे, आप घर में बैठेंगे, जज अपने घर में बैठेंगे, दूसरी जज अपने घर में बैठेंगे, और आपकी ऑपोजिट काउंसिल अपने घर में बैठ के आर्गुमेंट करेंगे, and effectively judgment will be pronounced. We have to think out of the box. Virtual hearing is something like that. 2019, nobody could have thought that कि हम टीवी पे भी आर्गुमेंट कर सकते हैं. वही नहीं होता है ना, टीवी का बड़ा सा स्क्रीन होता है. Because of virtual hearing, you take a big screen which is compatible with a computer and smart TV. I take this opportunity of sharing my experience in the first phase of the pandemic. Among other things, myself and Justice Savitri Rathore were given the assignment of hearing criminal appeals. And as everybody knows, as a judge or as a lawyer, in criminal appeal, nobody wants to argue finally. They only want an admission and a bail order. And it recedes to the dormant file. As it is happening in Uttarakhand, was happening in Uttarakhand also. There were cases of 2012, 2013. I was surprised because in Odisha we have cleaned the 2012-13 cases. In Jharkhand, I went and saw that there is cases of 1994, 95. अब क्या रखा है 1994, 95 केस में? आधे तो मर गए हैं उसमें से. So we took out the cases. Nobody appeared initially. We listed a number of cases. एक साथ 25-30 लगा देंगे क्योंकि कोई आ नहीं रहे थे. Somebody says, sir, it is to be ascertain whether the accused who is on bail is living or dead. मर भी गया होगा. तो first we started calling for if he is dead or alive. एक दो दिन के बाद I said to Justice Rathore, it doesn't look good. माने asking somebody whether he is dead or alive, especially when he is a petitioner before you. So we developed it in a way. We called for a report about his whereabouts and well-being. कहाँ पे हैं वो और कैसे हैं, ठीक ठाक है ना. तो अगर मर गए होंगे तो they will report he is dead, and if he is alive, he will be intimated by through the SP or SSP and SHO, जो ISC कहते हैं, Inspector in charge of the police station, that your case was listed, your advocate did not appear. And if on the next day nobody appears, the court will appoint a amicus to argue the case. Most of the cases they said, जो होना है हम जाएंगे नहीं, हम यहाँ कहाँ जाएंगे. And we again prepared a panel of a database बना, a panel of lawyers who are eligible to be appointed as a amicus to argue a case. क्योंकि अभी Supreme Court has given judgment, I don't remember the citation exactly, but the ratio is that in a murder case where the punishment is imprisoned for life, then the counsel arguing must be having 10 years of experience, otherwise he cannot be or she cannot be appointed as a amicus. And in a death sentence, only a designated senior can be appointed. So we start, first thing we did, we prepared a database. We collected telephone numbers of all the counsels that they were eligible, and also collected the emails ID. We also shared our cell number with all the additional government advocates who were attached to my court. Even Mr. Padi appeared in some cases. I gave him my phone number. उसका एक disadvantage भी है. उसका disadvantage ये है कि मेरा टेलीफोन नंबर उड़ीसा के सारे वकील को पता है, और ये जज के लिए अच्छा शायद नहीं माना जाएगा. So I am phasing out my old phone and taking it. This is a lighter vein. Don't take it very seriously. So we also created an email ID for the of the court number 2, old building, to facilitate submission of written arguments and list of citations, etc. Even transmission of document. उसी समय हमने वो WPCRL habeas corpus भी सुनना शुरू किया. And in that process, that off-quoted in the social media, Chinmay Jaina case was also pronounced by us, where Justice Rathore said that law knows no bound, and it has been very much appreciated. आप नहीं पढ़े हैं शायद जजमेंट. चिन्मय जना कोई नहीं पढ़ा है? सरप्राइज्ड. आप तो पढ़ा होगा. एंड मिस्टर संजय कुमार मिश्रा नहीं पढ़ा. एनीवे, अब जाके पढ़िए. So we created an email ID, and we accepted written arguments and submissions of application documents. This is prior to this online filing, and उसके बाद the second phase में online filing and this thing, the paperless court started. And in the first phase, could you believe we disposed of 125 criminal appeals? And I believe, and I think, I hope so, this is a record in Odisha High Court. इतना कम समय में इतना ज़्यादा केस criminal appeals. हो सकता है रीट्स हो सके. रीट तो रिप्रेजेंटेशन डिस्पोजल 1000 एक दिन में हो जाता है. So there is advantage and disadvantage, and the need of the hour is to think out of the box. Thinking out of the box, like abhi in Uttarakhand as well as in Jharkhand, many advocates will come and say, sir, advocate from Delhi will come, advocate from Calcutta will come, so you have to give a particular date. और दूसरा डेट उनके लिए सूट नहीं कर रहा है. मैं बोला नहीं दूंगा मैं डेट. I'll fix my diary as per my convenience. आपको अगर नहीं आना है तो आपको you can argue virtually. We will give you a virtual platform. You ask your client, then they will say, sir, I have to consult my senior advocate. ठीक है, pass over कर दिए चार केस के बाद आने. Then they will come, sir, we are ready to argue virtually. And many cases are being disposed of. And this can be adopted. I don't say it is a perfect this thing, or that I am a perfect judge. Yeah, I don't say that what I do is the perfect way of doing things. This is what my experience is. You may appreciate, may adopt it. You can devise your own way of doing it. Because I know that some of you eventually will become judges also. And hope you will become good judges and deliver good judgments. So thinking out of the box is what is required at present. And a database has to be prepared. In Jharkhand, we see that the computerization is very far behind. Though it is neighboring to the Odisha High Court, Odisha, state of Odisha, it is in fact thousands of miles away from the state of Odisha. A very big challenge before me, because and nobody wants to change. Everybody wants status quo. जो सच चलता है चलता रहने जो. Nobody wants human tendency, no change. जैसे चल रहा है ऐसे चलता रहे. So these are the two aspects which I wanted to share my thoughts. There was some discussion by Justice Talpatra. He is a very wise and erudite judge. Very beautifully he pointed out the problem. I just want to add certain things. When I was a district judge in 2002, foremost judge of Supreme Court, Justice G.M. Dharmadhikari, was the Chief Justice of Gujarat High Court. And I had an occasion of listening to him. At that time, 2002, you believe what will be the volume of cases? It is much less than what it is now. But still, at that time, Justice Adhikari, Dharmadhikari said, जे हमारे जो पहले जज हुआ करते थे, जो क्या कहते हैं, बहुत नामी जज जो जाने जाते थे उनके न्याय करने की कैपेसिटी के लिए, वो और हम में ये फर्क हो गया है कि वो न्याय करते थे, हम निर्णय कर रहे हैं. They were doing justice because they had time. They will have 2, 3, 4, 5 cases, and we will have 20, 15, 20, 30 cases. Now, what is the situation? ना हम न्याय कर रहे हैं, ना निर्णय कर रहे हैं. Neither we are doing justice nor deciding cases. We are disposing cases. And there is a mad rush to dispose of cases. I see judges day in and day out passing orders, thousands of orders, representation disposal. So this is my prayer. Okay, Annexure 7, dispose of. Somebody has come to you saying that, sir, this authority is not listening to me. He is not giving me my pension, my DCRB or other benefits, service benefit, other benefits, or leave, or for that matter, my compensation for the land acquisition. and you ask him to go back to him? And then what will happen? ये उत्तराखंड में भी है, झारखंड में भी है, उड़ीसा में भी है. मैं 3 स्टेट में काम कर चुका हूँ. And I do not like disposing unless they pray that, sir, this problem can be solved if a direction is given for disposing the representation after hearing me, after taking into consideration. So, only when there is a prayer for disposal of representation, that should be order of disposition, otherwise not. In fact, Justice Chandrachud, when his lordship was about J3 or J4, he wrote a very short cryptic judgment that representation should never be direct to be disposed of. Court exists only for deciding a list, not for directly relegating the person to the same authority who has rejected his application or who is sitting over his application. It will only breed corruption. And if I am not wrong, Brother Talpatra may be knowing, in the Department of School and Mass Education in the state of Odisha, they keep a list of a register कि कोर्ट जो डायरेक्शन है उसको एक अलग से लिस्ट रखते हैं. And somebody was telling that if there is a direction from the court, there is less chance of any vigilance inquiry. So we can safely pass any order, representation. So it also gives rise to corruption. That as the central government councils or the deputy solicitor general, additional solicitor general, you should always oppose any attempt on the part of the judge to direct a disposal of representation. Disposal of representation is in fact a vicious circle. It was started initially by many judges of the High Court because of the heavy pendency of the cases. Now it has so happened that has led to such a situation that people are filing only for getting a order of representation so they can raise a cause of action. For example, a contractor failed to discharge the work order given to him. After 7 years, he filed an application before the High Court. And the High Court, what should have been done? He should have approached the civil court for a money decree or a title suit. Instead, he came to the High Court, and the High Court gave a order that the executive engineer shall consider his case and dispose of his representation. And the executive engineer disposed of his representation, say it is time barred, or it is not so. That petitioner, he filed a contempt application. First contempt was disposed of, saying within 2 months, dispose of the contempt, dispose of his representation again. And the second contempt was filed after 3 months. Then the judge will sit and decide whether the decision taken by the executive engineer is right or wrong. Where does the contempt court have jurisdiction to decide that? The contempt court is only to decide whether there has been a willful and deliberate disobedience of the order. Nothing more, nothing less. He cannot decide this representation जो ये ground दिया था reject करने की ये गलत है. He cannot do that, but it is being done. And that is where you step in. आप Bar Council of Odisha का I read और Bar Council of India का जो rules है, इसमें duties of the advocates एक है, पढ़े हैं इसे, but actually it is a very nice reading. You should all of you should read it. There is one thing that you should fearlessly campaign the rights of your client, and your client is the Union of India. You should not be afraid to face the wrath of the judge, even if he is me. So I tell my 2 young central government councils, please don't be afraid before me. I may be angry for some time, but in the ultimate analysis, we'll come to a just decision. So my advice that you see that the court don't take a shortcut and put the Union of India to unnecessary lengthy litigation. There should be a quietus to the litigation that is raised before the court. No disposal of representation. And even if there is a representation disposal, there shall be no contempt in a no course order. Unless there is a mandamus, no contempt. You have to fight that. Now somebody, मैं 3 स्टेट में काम कर चुका हूँ, Odisha, Uttarakhand and Jharkhand. Somebody told me, Justice Mishra, there are 50,000 representation pending before the government, and the government is not taking a decision thereon. Then I said, brother, 50,000 times the High Court failed to do its duty. Why don't you see that way? Am I making any sense? Is it nonsense? ये बड़े भाई क्या बोल रहे हैं? So I may be, if somebody knows some judges who dispose of only representations, may be critical of me, may become violent also, and may also act like a Shakuni. I don't care. I believe in Lord Jagannath. He is my savior, and he is savior also, जो भी मेरे पीछे पड़ेगा. And he will do the justice. He will not dispose of any representation. Lord Jagannath never does. There is also a talk of Honorable Law Minister talk about the district court or the trial courts. The 90 to 95% of the litigations are pending before the trial courts. In fact, when we went to the first ever seminar in National Judicial Academy at Bhopal, there were 88 district judges on the same day in a room of this size. Justice Yuan Bhatt was one of the resource persons. He was the former Chief Justice of Madhya Pradesh. He was a district judge from Kerala cadre, went to become Chief Justice of, I believe, Chief Justice of Guwahati with him, and Guwahati, and then went on to become Chief Justice of Madhya Pradesh High Court and retired. He told us that the district judiciary is the backbone of Indian judiciary, because no Supreme Court, no High Court can take up 95% of the total litigation, and the trial judge never disposes a representation. He gives a judgment in every case. And I have been a district judge, a trial judge, and also a High Court judge, though the length of High Court judge is longer than that of a district judge. The work of a district judge is very difficult. You see, a person who kills a bird can be of two professions. One butcher, the other is a hunter. When the butcher kills the bird, what he does? He takes a knife and slaughters it with his hand. And the process, his hand is brushed in, his dress is brushed in, fleshes, feathers, blood is spread all over his body. But when a hunter kills a bird, what he does? He takes out a gun and shoots it, or takes a bow and arrow, shoots it. In the process, his hands are not blood stained. The same is the situation between a trial judge and an appellate judge. When a trial judge pronounces a judgment of conviction and hands down a punishment, be it a death sentence, imprisonment for life, imprisonment 10 years, 7 years, 3 years, 1 month, he has to look into the eyes of the accused and say, here I found you guilty and I sentence you to this. And he has to go through that agonies and pains of that human being being convicted and sentenced. लेकिन हाई कोर्ट जज को नहीं होता, because I speak from my experience. Every time I convicted a person, I'll come back to my chamber and I'll feel jitters. There will be butterflies in my stomach, because I could see the O's in the eyes of the accused. But when I became a High Court judge, and I also dealt with death penalties and life imprisonment, so many cases, I never felt that even if I dismissed the appeal, because I didn't have to see in the eyes of the appellant or the accused and say that, yes, you are guilty and you are hereby sentenced to death. एक बार क्या था मैं death sentence दिया था, and I could really not withstand the pressure of it. So the people who think that the work of district judiciary is easy, and it is only the high courts who are doing the justice and glorifying the law, rule of law, are not correct. But at the same time, I must say that the high courts, let me tell Brother Subhasis an experience. Just after the amendment of Section 41 and in session of 41A to the Code of Criminal Procedure, before the pronouncement of Anesh Kumar, a seminar was being held in the Odisha Judicial Academy. There is senior district judges were there, so many persons were erudite speaker were there. I was asked to moderate a particular session on bails and remands. When I started this session, I asked 2-3 senior district judges about Section 41, and to my surprise, they were not aware of the amendment. And then, in my own style, I started saying that how can you remand somebody who is forwarded to the produced before you, whose punishment is less than 7 years, and things like that. And I said that the district judges it is unbecoming of a district judge to reject bail application in a case involving 506 or 379. This is offenses. And the main speaker of that session was Justice P.K. Mishra, the very erudite and what you call one of the finest judges that Odisha High Court is produced, who went on to become the Chief Justice of Patna High Court for a very short period. And he earned a very high and good reputation as an erudite and eloquent judge in Madras High Court. He intervened me and said, Sanjay, you stop and give a mic to me. And he said that it is the High Court who has timidized the Odisha district judiciary. And there was an altercation. We had, in fact, I have seen Justice P.K. Mishra, who is fondly known as Kuni Baina. When I was wearing a half pant, I had come to his house quite often. He was also junior to Justice R.C. Patnaik. And my father used to brief him also in many cases. But I had my ideas then, and he had his ideas. He gave instances where, for granting bail, district judges and magistrates were put under suspension, proceeded against departmentally. So I take all the available opportunity to say that this is not the same High Court that we are speaking of. We have a bigger horizon. We will not punish somebody if he passes an order with a clear conscience or grants bail with a clear conscience to a person who is entitled to bail. So as a member of a elite fraternity, that's a legal professional, it is our duty also to come and support the district judiciary and see that they are given the right kind of infrastructure, moral support, and also assistance in the legal field. These are the things which I thought I should share. In fact, I never had the time of preparing a speech because till today 9:30 I was correcting and signing orders because so many cases were being listed yesterday. But lastly, I must thank Sri Prasanna Kumar Pari, the learned Deputy Solicitor General. Kahan gaye Pari ji? Nahi hai. In fact, I was not very keen on coming and attending the function because of my heavy preoccupation. And you know, when you take a new responsibility and only for 7 to 10 days, it is only not even 2 weeks. Monday, 20th, I took oath. So this big responsibility is there. So I want to take advantage of the entire vacation to take out, have a feel of the High Court. But Mr. Pari, without my consent, inserted my name in the validity session. But I thank him for that. I thank not only Mr. Pari and his team of central government councils, and I wish all of them all the best, and what do you call, happy Holi to everybody also. Do I have to say it is validity session, but it is not closure of this session. Thank you very much. Jai Jagannath. Bande Utkal Janani. Jai Hind.
Thank you, sir, for your beautiful and erudite and igniting presentation, sir. It is said that one honorable judge is known and remembered from the judgment which he writes, because the judgment reflects the mind of the honorable judge who writes the judgment. I recall one judgment delivered by Honorable Justice Sri Misra, that is Bibas Gowda versus State of Odisha, that is reported in 2015. I was sitting in the courtroom. One young advocate came before Honorable Justice Misra, and his grievance was he had filed a representation before the district magistrate and alleging that he was wrongly arrested. My lord asked the young advocate, "What is your representation?" He just started murmuring and he started reading from the bottom. And my lord Justice Misra found that for some little allegation like involving 506 or 294, that person was arrested. And it was after delivering of judgment of Ornesh Kumar versus State of Bihar in 2014. Honorable Justice Misra issued notice, and that was the first judgment in our High Court where my lord decided the law that if the police going beyond issuing notice under section 41A arrest a person, then police is liable for action. Also the judicial officer who sends the accused person to the jail, he is also liable for departmental action. And it is also clarified in that judgment, if the ratio decided in the case of Ornesh Kumar is violated, then the Honorable High Court under whose jurisdiction it is violated, contempt application will lie before the said Honorable High Court. And basing upon this judgment, many litigants are getting benefited, and I remember this case. Thank you, sir. Now I request Sri Anil Kumar ji for his presidential address.
Namaste. Good evening. Honorable Justice Sanjay Kumar Misra, the Honorable Chief Justice of Jharkhand High Court, Honorable Mr. Justice Subhasis Talpatra, Honorable Judge of Odisha High Court, the Honorable Justices who were sitting off the side dais, the Deputy Solicitor General of India from different high courts, and the person sitting in the dais, Prashant Pallav, my colleague and Deputy Solicitor General of Jharkhand High Court, and Sangeeta Pradhan, Srimati Sangeeta Pradhan, learned Deputy Solicitor General of India, Sikkim High Court, Senior Standing Counsel and CGCs. Here now we are at the verge of the conclusion, and this is the valedictory session. Therefore, now I'll request, so far as there are two sessions which has been made with regard to the working session. One was with regard to the national security, our priority. So far as the national security is concerned, it is not only with regard to the border, as it has been said by the in the morning itself, so far as the speakers are concerned. There are several things which has been explained by the speakers, but so far as the role of the advocates as a standing counsel, senior standing counsel or panel counsel of the Government of India are concerned, that is required to be taken note of. But I'll just say only because few words with regard to that part. While dealing with the cases, while dealing with the cases relating to the cyber crime, environment law, energy security, these are the subject which is also a national security threat, so far as that part is concerned, and to that extent the role of the government councils become very important. If at all we are not in a position, we are in a position to defend, so far as the stand taken by the executive with respect to those acts which causes national security to us itself, then it becomes very easier to protect so far as the national security is there itself. I am not adding with respect to that part because now I am addressing with respect to the voluntary. The second subject was with regard to the virtual professional aspect of the virtual hearing. Now, so far as the professional aspect is concerned, the word coin which has been therein is the professional aspect of virtual hearing. An advocate, how he has to deal with the client and how he has to deal with the advocate, the court itself. This becomes very important. First, an advocate is to come across with the client itself. Once he is coming across the client, there are several facets. Previously, it is only when it is in the physical mode, the client used to come to the advocate, he used to express his and discuss about his subject itself. But by virtual mode, we can say even a person sitting in the village, if the network is there, then we can discuss on virtual mode with the client, and the time, money and the everything can be shortened itself so far as that part is concerned. But the fact remains, even the document which is being shared, immediately it is being used therein itself. As a government council, we can also use so far as the virtual mode, and everybody is using also now either by way of email, by way of WhatsApp and by way of telephone. We used to get immediate instruction before the matter are being heard, before the court itself taking into consideration the urgency of the matter. Now if we are using so far as that part is concerned, then definitely it is helpful to us and also helpful with regard to the delivery of the criminal the justice delivery itself. Therefore, so far as these two aspects are concerned, our speakers have stated so many things, and the advantage and disadvantage of the virtual hearing has already been told. Now, so far as our Chief Justice, Honorable Sri S.K. Misra has stated about his experience as a judge, so far as right from the lower court to the high court itself, and so far as the different aspects are concerned. Now you are all are aware with respect to, and I'll request so far as these things are concerned, you will brought into your real life also. Now I'll thank, so far as the guests are concerned, the Honorable Minister Sri Kiran Rijiju ji, who have participated in this program and spared the time for this program itself. I'll also thank to Honorable Mrs. Justice B.V. Nagaratna, who have also participated in the inauguration session. Then I'll thank Honorable Mr. Justice S. Muralidhar, the Chief Justice of this Odisha High Court. I'll thank Honorable Justice Sanjay Kumar Misra, who has taken his time to participate so far as this conference is concerned. I'll thank Learned Sri Tushar Mehta, the Solicitor General of India, who have also spared his time and shared his views with you. I will thank Honorable Justice Subhasis Talpatra, who has also spared his time for this function itself and stated so many things to you. I'll thank Honorable Justice C.R. Das, the Honorable Judge Calcutta High Court, who has also came and shared his views with you. I'll also thank Honorable A.M. Buzur Barua. My Lord, just I am not pronouncing it at all, that is the same. He is also sitting right from the morning itself so far as the entire conference is concerned. I'll thank Honorable Dr. Vidyut Ranjan Sarangi, the Honorable Judge is also sitting there. I'll thank Honorable Justice Kalyan Rai Surana, Honorable Judge Guwahati High Court, who is also sitting here itself, Lord. And Honorable, I'll thank Learned Sri Anil C. Singh, who has also came from Bombay and participated in this conference. I will thank Dheeraj Trivedi, Learned Deputy Solicitor General of India, Calcutta High Court. I will thank Sangeeta Pradhan, Learned Deputy Solicitor General of India, Sikkim High Court. I will thank Sri Vidyut Majumdar, Learned Deputy Solicitor General of India, Tripura High Court, and the other, all the Deputy Solicitor General of India, Sri Prashant Pallab, Learned Deputy Solicitor General of India, Jharkhand High Court, Sri Mato Kato, Deputy Solicitor General of Guwahati High Court. All these persons and senior the senior standing council and the panel council itself who have participated in this program. Now, so far as the program is, this is the validity session I am including so far that part is concerned. And most important thing, so far as the, I will thank to Mr. Prasanna Kumar Padi, who has organized this program in such a huge manner, and all we have enjoyed since the morning itself. So far as the management which has been done by his team itself, the manner in which he has provided the food, the tea and everything to all the members who have participated here, I am thankful to him. And this is the first occasion when we have assembled here, and I hope that next time, if at all we get an opportunity at Ranchi, we will also try to give all these things itself. And I definitely, I'll give a word to the Chief Justice Sanjay Kumar Misra that if whatever help we can provide him so far as the Jharkhand state is concerned, and we will do it in all angles so far as an additional Solicitor General is concerned, or as an advocate, senior advocate is concerned, or the advocates support and cooperation will be definitely in the justice delivery system and in administration by the Honorable Chief Justice. This is my words I am taking from here itself. Thank you. Thank you.
Thank you, sir. Now this is the time to offer our law of affection to the honorable guests. Now I request Sri Bimbisar Das sir, the Senior Panel Counsel, to felicitate Honorable Justice Sri Sanjay Kumar Misra.
By the way, I feel very privileged to receive this award, this felicitation from Mr. Bimbisar Das. इनका बात मैं बताऊं, जब भी उड़ीसा हाई कोर्ट में क्रिकेट मैच होता है between the judges and the lawyers, he is one of the umpires and he has always given me not out. Even is out. Thank you.
Well, information is in the judiciary, in the legal fraternity, possibly as the first qualified umpire. Possibly.
Thank you. Thank you.
Now I request Sri Sanjeev Swai, Senior Panel Counsel, to felicitate Honorable Justice Sri Subhasis Talapatra ji. Now I request Sri Radheshyam Chimanka to felicitate Sri Prasant Pallab ji. Radheshyam ji Chimanka. Now I request my brother Partha Acharya to felicitate Sri Anil Kumar ji. I request Sister Babita Sahu to felicitate Madam Sangeeta Pradhan ji. Now I request my brother Sri Prabhu Prasanna Behera to felicitate Honorable Sri Justice Sanjay Kumar Mishra and Honorable Sri Justice Muganka Sekhar Sahu.
It's a pleasant surprise. I thank the organizer and all the dignitaries on the dais. Thank you.
I request my brother Sri Dipti Ranjan Bhokta to felicitate Honorable Justice Sanjay Kumar Mishra. Now this is the time for Purnahuti of this Yajna. The Prathama Ahuti which was offered in the morning. Now we are going for Purnahuti, and I request the Chief Guest Honorable Sri Justice Sanjay Kumar Mishra before putting the Purnahuti, I request Madam Sangeeta Pradhan ji to offer vote of thanks.
A warm and graceful evening to everyone present here this evening. As William Arthur Watts once said, feeling gratitude and not expressing it is like wrapping a gift and not presenting it. It has been an honor to be a part of this wonderful event, the August Gathering. I deem it a great honor and privilege to be the one making the closing remarks and extending the vote of thanks on this memorable occasion. First and foremost, I, on behalf of all the councils of Central Government of Eastern States of India, I extend my most sincere thanks to the Almighty God for making today's event a grand success. From the depth of my heart, I thank our chief guest, Honorable Mr. Justice Sanjay Kumar Mishra, the Chief Justice of Jharkhand High Court, not only for valuable time to grace this occasion, but also for enlightening us and sharing his experiences. Thank you, sir. My heartfelt thanks goes to Honorable Justice Subhasis Talapatra, High Court of Odisha, for his precious words and valuable time. Thank you, sir. My hearty thanks goes to Anil Kumar, sir, Additional Solicitor General of India, for enlightening us and his valuable time. My special thanks goes to my colleague, Sri Prasanth Pallab, for his time and beautiful words, especially for me. I would be failing in my duty if I did not thank all the participants who have made this event joyful and enjoyable with their presence and performances. Above and beyond, my hearty thanks goes to the backbone of this event, the organizer, Sri Prasanth Kumar Pahari, learned DSG Odisha High Court, and his entire team, who went an extra mile and made this event a grand success. They deserve a great applause. I thank all the honorable judges sitting off the dais for their valuable time and for gracing this precious occasion. I extend my heartfelt thanks to all the Assistant Solicitors Generals who have come from across the country to grace today's occasion. My heartfelt thanks goes to all the DSGs present here today from various parts of the country, learned senior central government councils, learned central government councils, and all the members of the bar present here today to grace this occasion. My heartfelt thanks goes to the press and media who made this occasion successful. My sincere apologies if I have missed out on somebody. Thank you again, all assembled here, for making this event a grand success. Thank you.
On a small interruption, I'm here. I express my gratitude those who have participated here. Also, I may express my gratitude not all the inaugural sessions those who have present here. I have also gratitude specially to two judges who rushed from the Guwahati, Justice Kalyan Rai Shurana ji, also Justice Achintya Malla Murjabarua ji. Those who are present here have a even though it was cancelled thrice, ultimately Lord Jagannath permitted us to do so, and for which we are fortunate we have got two eminent judges of our High Court now. Now the Chief Justice of Jharkhand have our pride, Justice S.K. Mishra. Initially, sir is not given time if you will hold it 29th. If it is shifted to this time, sir is given consent. In the meanwhile, Lord Jagannath Passive as a Chief Justice have a wonderful and when I asked the Tripura, because your decision is that those who have participated in different states, their High Court judges should be with us. when I asked Tripura, my learned colleagues, he told me our representative is there. You approach Justice Talpatra ji and he will represent both Odisha and Tripura. So again, once again we have a question. And I think both the two judges we have, Odisha High Court Justice M.S. Sahu and Justice Sanjay Mishra. And all other we have a congregated here. If we are try our best to do so, if any mistake we have, just be excused. And whoever the delegates here, we will try our best to do so. So if any mistake is there, then they also excuse us. Thank you. Just a Bande Mataram.
I request Honorable Chief Justice Sanjay Kumar Mishra to declare the function closed.
I declare the first conference of central government councils of the eastern state of India closed.
Thank you, all of you. And I request all the members to join with us for high tea. Thank you.
Okay.